access to the chats. I don't know if it's just me.
I've started the recording. If it continues, even if the battery stops, then it's good.
Does anyone else not have access to the chats? I can't see the chat box.
You need to log out and log back in.
But everyone else has access.
Yes.
Okay. All right, Mr. Brown, I'm officially handing over to you.
Okay, well, don't go too far because I might just need you. Okay, good morning, everyone. My name is Richard Brown. I have posted my email address. I shall do so again just to make sure that everyone can see. And that way, you don't have to worry too much about the slides. You can just email me and I'll email you a set of the slides back. Makes life a little bit easier. The reason why we do that is simply because these are the same slides that I've been using since I started doing these lectures. I've just been adding to them. So this is really the real deal lecture that's been going on for the last, I don't know, more than a decade or so. But be that as it may. So good morning to everyone. This is my first time. About 50% of the screen is taken up by my hair, which, you know, unfortunately is not going anywhere today. But let's get through this as best as we can. Can everyone see the slides? Let's start there. I have shared the slides.
Yeah.
Can everyone see that? A general overview aimed at introducing participants to the practice of labour law?
Yes.
Yeah.
Okay, great. That's the first slide. Okay, so a lot of you would have done some of labour law at university, and I hope everyone did it, but you never really know. In my day, it was an elective. Is that still the case? Okay, well, nobody's answering, I suppose.
No, it's compulsory now, so it's compulsory.
Is it compulsory? Okay,
Yeah,
well,
you
good.
can get advanced labour law as an elective.
Okay, well.
At UNISA, it's not compulsory because I didn't do labour law.
Okay, so it seems like we got a bit of
It's compulsory now at UNISA because I had to do it as a compulsory module.
Okay, well, that's good to know. But it seems like we don't have a unified basis on which we're starting. Some of you have done it, some of you haven't done it. And also your experience during your articles would also be very different. I would imagine that not everyone does labour law in their firms. I'm at Herald Gee Attorneys, and that's all I do every day for the last 23 years is labour and administrative law. So the issue really is to understand where we are now, you've got to understand a little bit about where we come from. Way back when in the day, black people couldn't organize, they couldn't gather in large groups, but the one exception was in the area of labour law. They were allowed to form trade unions and organize. There were terrible strikes, huge strikes that used to go on for months at a time. And the need to regulate those strikes to make sure that, you know, the economy could get back on track, all of those types of things, it was essential. So black people were allowed to organize in trade unions. And from there, as you can imagine, it was a hop, skip and a jump before COSATU was formed. And the trade unions really became the vehicle for a lot of people to express their political views and everything else that goes with it. So that's part of our history in South Africa. It's no mistake that we have a tripartite alliance ruling the country. So there's a lot of history there that unfortunately it's not a clean cut sort of, you know, here's a constitutional right, let's see what that duty now implies or what is the content of that duty. You've got to understand that that's a large part of labour law in South Africa was that sort of struggle against apartheid. The majority of civil disputes in South Africa is labor law, and everyone's sort of jumping up and down. What about MVAs? What about divorces? They reckon that something like 1/8 of the disputes that take place in the workplace actually make it into court or into some sort of forum. So if you think about all the things that gets resolved in the workplace using labor law principles, all of that falls under that banner of labor law. Every year there's about 180,000 labor disputes in South Africa. The vast majority is misconduct dismissals or conduct dismissals. But if you think about 180,000 disputes, each one going to a 3-day or 2-day arbitration, we just don't even have enough courtrooms, let alone arbitrators, to resolve those disputes. So labor law in South Africa, we need fast, efficient and cheap resolution of those disputes. In the Western Cape, we're running settlement rates. So for every 100,000 cases that gets referred here to the CCMA or to the various bargaining councils, they're running settlement rates of about 76, 78%, which certainly makes it a little bit more manageable because it's only about 22,000 cases that's going through into various dispute resolution fora. And that's essential for labor law. Imagine you get dismissed today. You're so hung up on this dismissal, you can't get past it. Sorry, that's my phone for some strange reason. But you just can't get past it. You stuck there. The longest running civil dispute in labor law anyway, BTR Samkol, took 13 years to resolve. And that was an absolute failure of the labor dispute resolution process. So obviously it needed overhauling. And that's the act that we have now. It's obviously derived from our constitutional right to fair labor practices. And to give effect to that constitutional right to fair labor practice, I'm moving the slide now, so I hope you can see that. So there's going to be a little bit of a comparison between the old labor law and the new LRA. Labor law in South Africa, it's not unusual. It's still based on normal contractual principles. But for the most important part for labor law asks the question, well, is it fair? So that fairness jurisdiction or that fairness inquiry is what we call the equity jurisdiction. And that's unique to labor law. Nowhere else, you pick up a contract from, I don't know, Lewis stores or something like that. Nobody asks, well, is it fair or isn't it fair? They look at the contractual terms and they try and set aside the contractual terms. We can take those contractual terms in a labor law setting and we can still ask the question, well, is it fair? The balance of power, that's also very important to understand because that's where the legislative interventions all come in to try and balance that power. And in that equation, where it's employers versus employees, the workers are always in the weaker spot, which is why you get this host of legislative interventions to try and balance that power. So if you can understand that, then you can look at some of the provisions where the legislature has sought to intervene in that relationship. And Basic Conditions of Employment Act, Employment Equity, Skills Development, even the Pension Funds Act. We're not going to be looking too much at most of those things. Of course, for labor lawyers, the most important is the LRA, which is why that gets its own slide so that it can subliminally sort of just hang out there in your subconscious. That's the most important for labor lawyers. Any questions so far? Please, this only works if there's some sort of interaction. Are you guys still there? I can't see anyone.
Yes, we're still here.
Yeah, there's
All
a chat
good.
section where people are talking.
Yeah.
Okay. All right, well, are there any questions so far? 4 slides in, but you never know. Okay, well, moving swiftly along.
Sorry,
Ask
a lot of
which
questions
batch
are
to
being
check
posted
here.
to the.
Well, there's now 3 of you talking.
A lot of the questions are being posted to the chat group. I think if you monitor that at the same time as the slides, you'll see a lot of the questions.
Okay, let's see if we can do that. That's quite a good idea. Oh, wait. Thanks, still good. No, which matter? Took 13 years. A BTR sample. They made tires out in the Eastern Cape. Any other questions? No. Oh. So what happened with BTR sample? Very interesting. Obviously, it was wage dispute. They went on strike. It was a bit of a wildcat strike, so there was a demand. But in those days, it was a bit of Wild West. It's not as regulated as it is now. So it was before the Labour Court and the CCMA came into view. In those days, we had what we call the Industrial Court. We also had conciliation, but it had settlement rates. It was pathetic. Something like 12% of all disputes got settled. Compare that to the Western Cape, where we're running 76%, Gauteng, high 60s, Durban, high 60s. The Northern Cape is the very best in South Africa. I think they had actually something like 3 disputes in its original year that went to arbitration. Everything else got settled. So that was amazing. But yeah, conciliation really does work, and it does get people moving along. And we'll talk about how they achieve that. But yeah, okay, let's just move swiftly along. I haven't scheduled any breaks or anything like that, so people must just shout. I'm just going to go until you say stop. I can't take it anymore. All right. So the most important for us today is obviously the LRA. This is not a very profound slide, but it is going to help you organize your thinking. The practice of labor law can be divided into litigious and non-litigious. Not very profound, but it is so, because what we do as labor lawyers, we tend to just focus on the litigious stuff, isn't it? There's a lot of attention being brought to cases and running trials and all of those things. But some of my best interventions as a labor lawyer has been on the non-litigious front. What am I talking about? We'll discuss that a bit later. At a very general level, all labor law disputes can be divided into 2 distinct areas: individual labor law and collective labor law. Why is that distinction important? Well, they have different processes that apply to the resolution of those disputes, which we will also focus on. By far, and please, the vast majority of disputes in South Africa is going to be on an individual front. So that is going to be something that you will have to take on board. There's a question, is this paper 3? If it is going to be in the exams, it's going to be in paper 3. It's going to be a very sort of general question around, could be anything, how to fill in a 711 referral form. One of the nice things about labor law, the actual act itself, the Labour Relations Act and all the forms that goes with it, was the very first example in South Africa of what we call plain language. So it's aimed at the lowest common denominator. The forms, they've got tick boxes, you've got to fill in your name, that sort of stuff. So it's supposed to make it as accessible as possible. To what extent that is a success, well, you're going to tell me, because you're going to fill it in during the course of the day so that you can see how easy or how difficult it is. So, moving swiftly along. So the non-dispute related labor law can be of the most interesting and challenging. New areas are constantly developing. What am I talking about? Talking about privacy issues, intersecting legislation. Think of the Companies Act and the Labour Relations Act. You want to get rid of a director. Well, the director is an employee as well. So you go to your shareholders meeting, you vote him out. Well, does that end his employment? You know, these are the kinds of stuff where labour lawyers make a difference. You have to run parallel processes. Think of municipal legislation. Everyone just focuses on how to get rid of the municipal manager. Back at the ranch is also an employee, and people tend to forget these things. The privacy issues, think about things such as your computer usage policy, which is all aimed at making sure that you don't download stuff or, you know, destroy the network or use the Wi-Fi and somebody else is trying to get on and, you know, you posting pictures and that sort of stuff. It's not meant to, excuse me, focus on what is it that you're saying to X, Y, and Z. The actual content of the email or the communication that you are sending. The privacy issues, your computer usage policies is never meant to regulate that. I mean, imagine a situation where you are emailing your doctor to find out about your COVID-19 test or your HIV test or your pregnancy test or whatever the story is. And here your senior partner's reading this and saying, what are you posting here? This sort of stuff. Is that allowed? Those aren't disputes that go to court, but you know, if you use your policy correctly, you should be able to stop those. There's section 197, transfers of a business as a going concern. So this is where you, for example, you buy a business, you don't like the staff, you want to keep some, you want to let some go. How do you do that? There's lots of verniekerij around that. True story, all my stories are true. This is what happened way back when in the 80s, bad old days. There was a clothing manufacturing concern. And this guy had an interminable trade union problem. And he wanted to get rid of some of the shop stewards. And he couldn't really do it. So there he was lamenting to his brother-in-law sitting in the surface corner in Muizenberg. The brother-in-law said, okay, tell you what, sell the company to me for 10 Rand. And then I will stipulate the employees that I want. And those who I don't want, they stay with you. And then you fire them. And then I sell the company back to you in a month's time for 10 Rand. And that's exactly what they did. And of course, the shop stewards were the only ones that were left out in the cold. So that sort of verniekerij. There's special legislative interventions there. Section 197, it does derive from a UN charter. South Africa is a signatory to the International Labour Organization. So there is a provision in there. A lot of our interventions in labour law comes from the ILO. For example, the whole push for a 40-hour working week comes from an initiative at the ILO called 888. So 8 hours of work, 8 hours of play, 8 hours of rest. You times that by your 5 working days, you get to 40 hours a week. Most people are doing much more during their articles. But yeah, you know, if you know where we're headed, then you can keep track of that legislative interventions as it comes along. I know I'm going pretty fast, so if there are questions, please stop me. I really don't mind, and I'll do my level best to give you an honest answer. How's it going so far? People able to follow? You can post questions and comments, and I shall see what I can do about responding. But in the absence of any further queries or questions, we shall move swiftly along. Okay, so we will discuss more of the 197 transfers a bit later on. Let's just talk a little bit about the individual disputes. Obviously, there's dismissals, which we will focus a lot on. It's one of those classification questions. Once you get to understand what the various dismissal options are, then you can get to understand the processes that go with it, which is the most important bit. The residual unfair labor practices, what are these? Residual unfair labor practices, well, it's anything that isn't a dismissal. So if you believe something is unfair, such as you get a warning, so obviously that warning could be for certain conduct. It could be for, you were supposed to know Section 65 of the Madge Court Act and you just don't. So it could be anything along those lines. It could be around promotion or demotion. So you do something wrong and suddenly you get pulled off a case, and first year CA gets to take that role. You see it as a bit of a demotion. You want to contest that. Promotion, obviously coming from a candidate attorney to a professional assistant, your articles does come to an end, so there isn't an expectation of some sort of progression. But once you're in, let's say you're all PAs now, and there's an opening for, I don't know, head of litigation or head of labor law, even better. And you contest for that post and you believe that it wasn't fairly adjudicated and you missed an opportunity. Well, you can use labor law to contest the fairness of that process. Benefits. What is a benefit? We'll talk a little bit about those things, but there's a lot of law around what is a benefit. So is it a benefit, for example, to park in the building as opposed to outside? Labor law seeks to regulate a lot of how those benefits are then perceived and how they are dished out and whether or not they're done fairly. So that's residual unfair labor practices, promotion, demotion, provision of benefits, but it really could cover anything. Any questions? Let's just toggle back to the question section. Oh, wait, here's a question here from, Pace is good. Okay, good. Thanks for that comment. The 888 mandate seems outdated nowadays with a 4-day working week and flexible working hour movement, although articles is a whole other beast. Yes, of course. Like I always say to our candidate attorneys, what are you doing at 4 in the morning? I hope it's not sleeping because you've got all this work to do. Anyway, articles is one of those amazing things. It's what you make of it. And so you're prepared to, kill yourself, work on the weekends. But if you think about it, what would normally be a 10-minute typing exercise for me and my secretary, I give it to you to do. It's going to take you 2 days of research, read the rule, check this, check the precedent, and then you come up and then it's still wrong. And I take my red pen and I go through it, but you learn from it. And then for you, the next time you do it, it's a 10-minute exercise. But the process of learning, obviously, you learn at your own pace, and whatever happens there, happens there. So, yeah, it's a whole different animal, and candidate attorneys and professionals really shouldn't be comparing themselves to, I don't know, a factory worker, because that's not what you are. But yeah, the world of work is changing. The whole 888 system, that's where we were. There isn't a new ILO convention that will be able to change that, but flexible working arrangements and everything else that goes with it. I don't like it. I like the office. I like interacting with my colleagues. We talk about all kinds of things, and that's how I learn a lot from them. They tell me about the cases that they're doing, and I tell them about my cases, and so we go on. Anyway, moving swiftly along. Automatically unfair dismissals. What do you need to do to know about that? So there's obviously in South Africa, as you can imagine, there's a lot of sensitivity around things such as all the discrimination the discrimination disputes, female, pregnant, color, religion, all of those sticking points in our discrimination legislation that filters through into labour law. If there is a case where you have been dismissed because of some or other arbitrary provisions, such as, I don't know, the length of your hair, the shape of your hair, the color of your hair, or anything like that, that could lead to automatically unfair dismissals. In South Africa, they speak specifically in the legislation about maternity. This used to be a big thing, and here's a true story. All my stories are true, promise you. Friend of mine from varsity, way back when in the day, she's looking for articles, and she goes for an interview, and the question goes something like this, and I hope this didn't happen to you, because it shouldn't happen to you, and I hope you never get to do this yourselves. But the question went a little bit about this. They asked her about her plans for having children. And she said, well, why are you asking me that question? Sure, do you ask all the male candidates the same question? Why is this an important consideration? And she said, you know what? I actually don't want to work here. And she took her handbag and she left. And she went to go work for SARS. And every sort of 2-3 years, that firm gets audited. It's very strange. It's completely coincidental. But yeah, read into that what you will. You can't ask people about things such as what's your plans for the future? Are you going to get married? Or are you going to have children and all of that kind of stuff? So, yeah. Well, there you go. Marika van der Westhuizen is saying that when she started as a legal secretary, this was a thing. You know, it's not a thing. Your plans for the future are your plans for the future. My only concern is, can you do this job or not? And I must assume that you must, and I'm not allowed to discriminate against you on the basis of, you know, at some point in time you want to procreate or not procreate. You know, that should make no difference whatsoever. If you do find those questions, you deal with them as best as you can, but they are completely, you must call them out. You know, evil flourishes where good people do nothing. So you must call them out and say, why is that a relevant consideration? You know, I'm here to do my articles, and I'm going to complete my articles, and I'm going to do very well if you give me the chance. So if you are being exposed to that sort of environment, you must call people out on it. And if you don't get the job, you must consider whether or not you want to actually do anything about it. So the automatically unfair dismissals, typically they arise, especially around procreation choices in a retrenchment scenario, where all of a sudden, in the middle of nowhere, they announce a restructuring process, and guess who gets selected for retrenchment? The pregnant woman, or the woman who just had the baby. And that's, you know, it makes no sense. We've got processes in our labour law to protect women and to ensure that you can actually procreate and make life choices and do what you must do like a normal person and still have a career. Why should you, just because you know, nature put this on you, it's up to you to save the species, let's put it that way. And now you can't have a career. It's just madness. We lose so many people to it because there's this unnecessary pressure put on especially women. Unfortunately, the men, not so much, but it is unfair. But yeah, I see there's lots of questions around that. Law firms act as if they're above the law. You know, nobody's above the law. It's really, it's up to you. Who are you letting get away with this stuff? If it's wrong, it's wrong. You must call them out on it. And let's see where it goes. It doesn't mean that every single dispute ends up in court. It just means that you're calling them out on it. Anyway, I'm sure there's going to be some more questions about that. When it comes to dismissals, 4 types that we generally tend to look at. Now, when you think about it, what we've done in labor law is, to a large extent, we've codified the law a little bit. Not every single case can find a home within these 4 categories of dismissals, but most, the vast majority, 98% of the disputes you will read about in the law reports will be able to fit into these 4 categories. We'll spend a lot of time talking about conduct, so that's easy enough. Capacity, what is capacity? Well, it's really incapacity. And there's 2 types. One is for ill health and the other one is for poor work performance, which we will also, they're very different processes. And we will talk about how to identify those various processes, because that, more than any other classification disputes, employers tend to get that wrong. What they do is they take your conduct, so how well are you doing? Were you supposed to know this? Did you do it? Didn't you do it? They take that and they roll it into a capacity issue, and they run a conduct process as opposed to an incapacity process. And it happens all the time, and you know they get it. Very often they get it wrong. So we'll talk about those different processes that attaches to that, just so that you can get to understand it. Operational requirements. This is really your retrenchment scenario, where a lot of and we're seeing a lot of it coming through now. I've been fairly busy this last 6 months. Lots of restructuring going on within the workplaces. Some people losing their jobs, some people retaining their jobs. Some employers are actually doubling down, and they're creating even more opportunities. Yeah, so it's been a mixed bag, but a lot of people are facing restructuring within their workplaces, and that's just a fact of life these days. Constructive dismissal. What is a constructive dismissal? Has anyone been constructively dismissed? I hope not. My very first case was a constructive dismissal case, and I'll tell you about it now. My client was a female, a very attractive female, and obviously growing up, there was a lot of male attention focused on her. So much so that at the age of 16, she was sexually assaulted. This led to huge intimacy issues. You know, everyone had to keep their space, that sort of stuff. She was working through it with a therapist, and there she was at about the age of 22. She now had a boyfriend. They were talking about moving in together. They were going to perhaps get engaged, that sort of stuff. But then the new CFO got appointed. And we all know this guy. He's like that, hey, how you doing? How's your day going? Give me a hug. And he was very touchy-feely, lots of that sort of stuff. And this made her intensely uncomfortable, as you can imagine now. Remember now, this is the 90s, just about when the new act was coming out. So there we were, and she was feeling uncomfortable. She went to HR to complain about the CFO and how touchy-feely he was. And HR then said, okay, she'll see what she can do. She went to the CEO and said, you know, I've got this situation where she's complaining about the CFO. CEO said, okay, leave it with me. Called him aside after one of the board meetings and said, you know, hey, come on, complained about this woman. You know, she's got intimacy issues. You must back off. And the CFO's, that HR lady is crazy. You know, this woman loves me. We get along like a house on fire. Anyway, dismisses it. He's on his way back to the office, and on his way, he passes her. She's on the ladder, stacking some stuff in accounts there, whatever. And he puts his hand under her dress. And that was it. She drops everything. She doesn't even go back to her desk to get her handbag. She comes straight to me. We declare the dispute. The trial eventually ran, but we did settle. But that's the example. Now, that's what we're talking about, constructive dismissal. It's where continued employment is made intolerable. Now, if that was you, I mean, there's no ways that anyone would disagree with you that that behavior is unacceptable. So how do we start? We start off with the person. Why is it that you're upset? Well, you're upset because you've got some intimacy issues and the CFO put his hand under your dress. Well, is that unacceptable? Well, everyone would generally say that is unacceptable. And then the question is, well, is that a standard that we want to hold all employers in South Africa to? And the answer would be yes. And if you get those 2 ticks, then you get the money. So they start off subjectively. Why is it that you upset? Now, once we get to understand that, then the next part of the question is that the standard that we want to hold all employers to? So we start off subjectively and we end up objectively. So we start off on the one hand, why are you upset? So let's say, I don't know, you're a Chelsea supporter, and why are you upset? Well, because Chelsea got a man sent off and lost 2-0 against Liverpool. Okay, so we understand why you're upset. Is that the reason? So you come to work on the Monday and it's just Liverpool everywhere, whatever, and you're terribly upset. Is that the standard that we want to hold all employers to? The answer would be no. So you wouldn't get the money. So that's always the issue, is that everyone can get upset. You can all get upset about anything. You can get upset about the fact that somebody else got a new laptop sponsored by the firm. But is that enough to get you over the line in the sense of, is this a standard that we want to hold all employers to? So, yeah, the fact that you're upset doesn't mean that it's something that can be applied universally to all employers in South Africa. So, of the 180,000 disputes that get declared each year, easily about 15,000 of them are constructive dismissal disputes. And of that 15,000 disputes, less than 1,000 actually succeed. It's a very hard case to make out. And there's lots of things against the employees. If you don't understand what those processes are, you're going to lead your client down a road, or they're going to lead themselves down the road, because 9 times out of 10, they come to me and there's too little that, it's just too late for us to do anything about. But yeah, it's a very difficult case to make out. What's the question here about the intimacy issues? Yeah, way back when we didn't have the act was still being drafted, so we were still under the old act. But it's just a good example to try and show that it's that kind of stuff, the intimacy issues, him putting his hand under a dress. The reason why we were able to sue the employer is obviously because she went to HR. Because normally if somebody puts their hand under your dress, well, that's assault. I don't even have to be an employee. I can get arrested. There doesn't have to be an employment relationship. But in this case, we were able to tie it into the employer because they're the ones that were supposed to do something about it. So it's that type of thing. Some of the other issues where we've been successful with constructive dismissal claims. My client had a baby, and in terms of the policy within the company, she got certain time off and certain benefits, and then she had a second baby, and they weren't very happy with this because, these benefits do cost a bit. And then by the time she fell pregnant with a third one, they started putting some unacceptable pressure. They didn't want her to do certain things, and that she suddenly had to pay for other stuff. and they tried to, in inverted commas, work her out. And we were able to capture all of those things in writing, protest, do what we needed to do, and then we pulled the plug in the sense of contesting the fairness of that treatment, and we succeeded. So it's again that sort of stuff. There's a question, am I correct to assume that due to the current wave of violence against women and children, that allegations of improper conduct of sexual nature will tend to be adjudicated in favor of the complainant with bigger settlements? So look, it really just, so if I were to sexually harass anyone, that would be a poor claim. You'd literally just be limited to whatever I've got in my bank account. The real money lies where you link that conduct into the employer, the hostile environment scenario, where let's say you are the only female amongst 20 male colleagues, and these 20 male colleagues are, they're just lagerlouts, they're loud, and they make inappropriate comments. You complain about it to HR, you say, please can we get it addressed? This culture in this workplace of people just with impunity referring to body parts and whether or not somebody's, VPLs and all kinds of crazy stuff. And the company takes those complaints on board, shakes their head, and then does nothing about it. That's a hostile working environment. Why should you have to put up with comments? If every day somebody came and commented on the shape of my hair, eventually I'd say, well, this is a bit much. It's arbitrary, to talk about body parts, to talk about all of these things. It doesn't make you feel very comfortable. How are you supposed to focus on getting on with the work? So it's that type of thing. It's the conduct on the part of the employer, and there are positive obligations on the part of the employer to try and make that environment as conducive as possible to a working environment. There seems to be a fair amount of questions on these things. Whenever it comes to these disputes, we never really focus on the settlements or the potential outcomes. You as a practitioner, it's up to you to focus on what you can prove and what you can't prove. What's going to happen after that is, of course, compensation, but compensation, it's within the sole discretion of the adjudicator. There are certain principles around it, but you shouldn't be focused on the money. You should be focused on getting their cases proven or not. I'm going to move on because we do need to get to those various processes that follows on the misconduct inquiries and the capacity inquiries. But once you have a dispute, what do? Well, all disputes, and I cannot emphasize this enough, all disputes around dismissal start out life at the CCMA. When does it not go to the CCMA? When there's a bargaining council. And there's something like 52 bargaining councils in South Africa. So it must go there. It goes there for conciliation. Conciliation is a very important part of the process. And once conciliation fails, or if it fails, then it goes to arbitration. It could go to arbitration under the Labour Court, which is also an arbitration in a sense, depending on the circumstances, or it goes to arbitration under the CCMA. It's a very simple process. I spoke to you about the 711 referral forms. I will share those with you. It should be in your packs, but you never know. So I'll just share it with you. You can also download it from the CCMA website. All the forms are there. So CCMA, labour law, LRA is all about accessibility. And if you can't find something and you complain, they will address it very swiftly. The 711 referral forms especially, because from time to time they do update them. I think the last time they were updated was about 3 years ago. But we'll talk about those things. So you fill in the 711 referral forms. They are very, very basic forms. They are aimed at the lowest common denominator. Now, You guys, during your articles, especially in civil law, there's going to be a huge focus on your pleadings and your drafting and your, how to set out these essential allegations. In labor law, it's not about the actual language. It's just about creating what we call a fuzzy concept of the dispute. So imagine you've got all these degrees behind you, and all that you're required to do is to just more or less indicate what kind of dispute are we dealing with. I mean, it's that sort of low level hurdle that you have to get over. So typically what I put in my 711 referral forms is the unfair dismissal of the applicant by the respondent. And that's enough. It gets you in. Once you are in the system, then they will regulate you from there. It's all about getting you in. If we can get more people into a dispute resolution process, we're going to be left with less people outside of the dispute resolution processes. You look at all the disasters in our recent past in South Africa. It's because people have no dispute resolution process against them, available to them. Something as controversial as land grabs. Well, if you want a house or a land, how are you going to go about doing those things? There's no ready-made process. You can't fill in a form, refer a dispute, and that gets adjudicated. It just doesn't exist. You can't access those rights, and that's when people start to help themselves. Even with the Marikana massacre, which we'll also discuss a little bit, that's a failing of labor law in essence, and we'll discuss why. But everyone remembers that. But what I want you to take out of it is that those people were left without a process, and that eventually erupted into the dispute that is currently called the Marikana dispute, the massacre, and the processes and the failings that followed on from that is what we'll briefly talk about, just to get you thinking about those things. It's not going to be an exam question. Relax. I just want you to think about those things. The concept is, if I can have a process and I can have you in that process, then surely I can then regulate you. And when I regulate you, well, then I can give effect to your rights, and I can, try and help you or not help you, depending on the circumstances of the case. So that's more or less what labor law is about. Rather have you inside a process than outside a process. And we'll talk about those processes in a few minutes. Moving on from there. So these are the exceptions to the CCMA referrals. We spoke about the first one, the bargaining councils. So what is a bargaining council? Bargaining council, the employer bodies and the employee bodies, and just like there's trade unions, there are employer organizations. So that's the equal and opposite equivalent of a trade union. Employers getting together to try and find a common position. So typical example of an employer's organization, the most recent bargaining council that was established was in the security industry. So there's two major, employer organizations in that industry, South African Security Association, and there's some other name that is mostly ADT. But these two employer organizations, they got together with the trade union. The main trade union is SATAU, South African Transport and Allied Workers Union. So that they would form a union. There's something called KAU. I forget what the first name is, but it's Allied Workers Union. So SATAU, KAU, and the two employer organizations, they represent something like 90-odd% of all the employees in South Africa. And here's a scary stat for you. We have something like maybe 300,000 South African police personnel. We've got maybe 30,000 permanent SANDF force, South African National Defence Force members. So that's what, 330,000. There are something like 600,000 security guards in South Africa. So imagine they got together and they decided, I don't know, let's overthrow the government or something like that. You know, you can imagine how powerful that force is. But be that as it may, it's for that reason in South Africa, you cannot have foreign ownership or more than 50% ownership of a security company. It has to be a local South African so that we know we can arrest someone, you know. If it's some third force sitting in, I don't know, London somewhere, they can just direct that their forces must take over the union buildings, let's say, or something crazy like that. But of that 600,000 odd security personnel, amongst those employer organizations, more than 80% of those members are employed by those large security companies. So what tends to happen, obviously, is that the employers and the trade unions get together, the employers and employees get together, and they understand more than anyone else what affects their business. So they regulate their own terms and conditions of employment. They have their wage negotiations there, and everything else that goes with it. In that security industry, a few years back, some of you might remember there were strikes, and it was violent. I mean, a lot of people lost lives just because that was an unregulated wage dispute, and it just, you know, they weren't able to find themselves, and they were forced into discussions to try and get things done. So hence the bargaining council got established. But before there was a bargaining council, there was a statutory council. The Private Security Industry Regulatory Authority, or CIRA, that's a statutory council. And what they're talking about now is moving, obviously, the statutory council into the bargaining council. So what is a statutory council? There's these things called sectoral determinations. So think about how difficult it is for trade unions to organize in things like on a farm. How are you, as a farm worker who is living on the farm, how are you going to protect your rights? It's going to be very, very difficult to actually do that. So what government did is they said, okay, tell you what, you guys can't organize so easily, you know, vessel at sea, ships, all of these things. So we form these statutory councils, and in the statutory councils, there's the wage board, and the wage board then determines terms and conditions of employment in that industry. And they publish the announcements, and they are called sectoral determinations, or SD. So the bargaining council in the security industry, that was regulated before by SD6, sectoral determination number 6. And slowly but surely you will see that SD6 terms and conditions is going to move into the bargaining council, and there's going to be a main collective agreement that will regulate the terms and conditions. And that way we just keep everyone nice and organized. So they talk about minimum wages, minimum legislation, minimum protections. All of these you will find in these sectoral determinations, which is regulated under the auspices of the statutory councils. The judge president of the Labour Court, Judge Wagley, he was for a long time, he was the head of the wage board for a lot of these sectoral determinations. Yeah, it's quite a thing. It still exists. There's 13 sectoral determinations, deals with things like forestry workers, distribution workers. There's even something for the taxis, you know, the sliding door operator. That is an actual thing. There's a designation called a sliding door operator. In Cape Town, we call them gachis. But yeah, they, you know, these guys are supposed to be paid on a certain basis. The extent to which it get enforced, of course, is a different question. Any questions so far? We've been moving swiftly along, but if there are questions, you know, please post them, and I shall do my best to answer them. Is everyone still up to speed? Are you able to follow? I'm not going too fast. If I am, please do not hesitate. I shall amend immediately. Private arbitrations. This is also another one of those exceptions. So the private arbitration space is a very simple. It's in your contract. So if I've got a dispute with my candidate attorney, we don't want our dirty washing being aired out in public. So we've got some private arbitration stuff that goes on there. That way we can try and get to the bottom of things and get it resolved. Excuse me, a lot of senior employees have private arbitration clauses. That way it's fast. You get to control the questions yeah, you get to control the process as well. It's not a bad thing, but obviously if there's a private arbitration clause, you can't go to the CCMA, you can't declare that dispute. You have to follow the precepts of your contract of employment. A lot of the time they just holus cabolus import the Labour Relations Act into the private arbitration. Very simple clause that says labor law principles shall apply in the resolution of this dispute, and voila, all the arguments that would normally be available to you in the CCMA is now available to you in the private arbitration setting. Anyone been to private arbitrations or had a private arbitration? It's always fun and games and those things. So we'll see how those things. Can a contract ask the jurisdiction of the CCMA? So again, if it's a private arbitration, then you can say it must go in a certain way. I'm sorry, I'm going to actually drop my phone off with my secretary. Let me just get rid of it right now. So you can have a private arbitration clause. That's the only way that you can actually stop people from going directly to the CCMA. But once you're there, then what? If it's about your conduct or your capacity or some other dispute, you're going to need labour law to try, or those labour law principles to try and get things back on track. But can you ask the jurisdiction? Can you have a clause in your contract of employment that says that labour law won't apply? Obviously, we can't have that because it's a constitutional right. So everything falls under the Constitution. And so even if, perfect example, the South African National Defence Force, which is in fact the very next thing that we have to talk about there. The South African National Defence Force, they are specifically excluded from the Labour Relations Act. It's one of the spooks and the spies, and the SANDF is excluded. Why? Obviously, we imagine there you are on the battlefield fighting the Zimbabweans or the Mozambicans or something, and the commander says, go on left flank, do this and what, and the guy comes along and says, no, we disagree. That's an unfair labor practice, that it's a hostile working environment, or whatever. You can't have that. It's a command structure. If you don't follow those commands, you could lose the war. It's that sort of thing. So they excluded them specifically from the Labour Relations Act. But as a citizen, obviously, you are subject to the Constitution, so you can rely directly on that right. So perfect example, a couple of years back, there was some protest around terms and conditions of employment for the SANDF, and about 200 of them, they put on their civvies and they marched on their union buildings. And of course, this was the closest thing that we came to a revolution. Because we've got the SANDF marching on the union buildings. and they sent in the black and white police, the ones with a checkered uniform and all of those kinds of things, municipal police force. With just a couple of shotguns, they dispersed the crowd. And then Minister Lindiwe Sisulu went on TV to say that all those soldiers who participated in this wildcat strike and marched in the union buildings are dismissed. And that was at 4 o'clock in the afternoon. And at 6 o'clock, somebody had said to her, well, you can't just dismiss them, you must give them a hearing, and you must hear this and you must hear that, because they can rely directly on the Constitution. So then she came and she said, well, what I meant was that those who weren't at barracks would possibly be dismissed. And by the 8 o'clock news, it was, no, we're going to have inquiries, and, so a complete climb down. And the reason for that is that those soldiers can rely directly on the Constitution because they've been excluded from the legislative intervention, which is the Labour Relations Act. So always remember that and understand that. So, you can never really oust the Constitution. You can't say South African constitutional law doesn't apply here because there's a sign above the door. If the door is in South Africa, it's subject to the Constitution. There are some constitutional court cases coming through now. What's that, Beloftebos? There's a reliance directly on the Constitution and everything else that goes with that. I'm not talking about the people making the claim. I'm talking about the actual owners of the property, the religious freedom and all of those things. So it's going to be some interesting debates around that process. But if you think about it as a concept that they're relying directly on the Constitution to try and find their defense, it's a very similar process when it comes to ousting the jurisdiction of the CCMA. So even though I can say, here's a private arbitration, you can't go to the CCMA, I still give effect to your right because subject to the Constitution, here's your private arbitration. So the question is, for a dismissal dispute at the CCMA during arbitration, legal representation is not automatic. Does the same apply for private arbitration? So if it's still an internal process, if it's me versus you in an arbitration setting, then, and it's still internal, in other words, nobody's been dismissed. If I have a meeting with my candidate attorney, why does the candidate attorney believe they're entitled to legal representation to come to a meeting? Where we're just going to be discussing quality of work, what happened, what didn't happen, what was supposed to happen, that sort of thing. If, however, I dismiss my candidate attorney and then I want to have a meeting, then obviously the candidate attorney can appoint somebody to come and represent their interests. Are they going to be allowed or not allowed? It depends on the rules and the reason for the dismissal. So the answer is we'll have to have a look at it. And internally, if it's an internal meeting, a pure internal meeting, very hard. But if it's not, if it's now taken, it's gone beyond the employment relationship, you've dismissed somebody, then, legal representation would notionally be permitted. So it's not an automatic right to be legally represented. But if you think about it, here's the concept. You steal a loaf of bread and some milk and batteries for your radio. They catch you. It's a fairly low cost, maybe 80 Rand. But there you are in jail. You can appoint senior counsel, junior counsel, and attorney, and you can run that trial. So, yeah, we can have a break at 10. So you can run that trial. But now, all of a sudden, you're in a labor law setting. You stole that stuff from your employer, and you're not allowed to have anyone with you. Or let's say you stole 100 million Rand from your employer. It's misconduct. The value of the goods and the fact that you would not automatically be entitled to legal representation is a problem for a lot of labor lawyers. But what I tell you, what it does do, so let's say I ask you to run a trial for me, a labor law trial. the very first thing you start thinking about is points in limine, isn't it? All of you go there. It's the first thing. Oh, this is wrong, that is wrong. And in that process, you bedevil the whole thing. That's where the difficulty comes in. Remember, labor law is all about access. People shouldn't be forced to plead in a certain way and, you know, that sort of stuff. So they lawyers tend to do that. A lot of the common law practitioners out there, especially in the civil law landscape, that's their first port of call, is the point in limine, which is part of the problem because it just adds another step to it. And because it's adding another step to it, you never get to the meat of the issue and you never try and get resolved. So what did we do in labor law? We had a look and we saw roughly 85% of all disputes concerns conduct or misconduct in this case, or capacity, poor health or poor work performance. So those three areas. And because of if that's 84% and we exclude the lawyers from that, then the CCMA arbitrators or the bargaining council arbitrators can get to the meat of the matter and get to the bottom of things and just get it resolved. I promise you, I once ran a trial in the CCMA, half a day, 6 witnesses. We got through everything. No points in limine, no clever points. We just dealt with the issues. We rolled up our sleeves, we dealt with the issues. This is the process of arbitration. With pleadings, you get to know exactly what the other side's case is, you consider it, and then you have your defense, and you got your witnesses, and everything's nice and organized. Labor law, you walk in on the day. Let's say it's an issue where you are entitled to legal representation. They can't kick you out. The arbitrator says, right, what's the issue? You got 2 minutes, you got 2 minutes, opening statements, done. Okay, I've identified the issues. Who's the first witness? Who's got the onus? The employer's got the onus, right? You start. Where's your bundles? Just exchange it there quickly. Take 2 minutes, go through it, 5 minutes. Okay, you need a bit more time, 10 minutes. Go through the bundle, 10 minutes, take instructions. But guys, really, you know what this dispute is about because you were both there. So the document should be more or less the same. The documents are more or less the same. And right, let's deal with the issues. Roll up your sleeves. Let's get stuck in. The witness comes and says, oh, it's this kind of issue, that kind of issue. And there's some cross-examination. The issue isn't like that. You're forgetting about the following X, Y, and Z. And then, you know, the answer would probably be, well, that's irrelevant because it's got to do with parking. And what's parking got to do with, Section 65, whatever the questions are. And at the end of the day, they make a decision. 14 days later, you get your decision. It's fast, it's efficient, and it deals with the meat of the issue. And that's the aim of the exercise. And they reckon that lawyers bedevil that process because we want to take points in limine and clever points and this, that, and the other. So that's always a difficulty. But we're not left without a solution. You can apply to represent, and we'll discuss Rule 25 of the CCMA and how that gets regulated. There's a question, the kind of questions that's going to come up in the admission exams. So admission exams is all about, you must be able to more or less understand what it is. There's not going to be a detailed question about constructive dismissal and whether or not this is. If you understand constructive dismissal, you'll be able to understand that we start off subjectively and end off objectively, but it's mostly going to be around the bread and butter questions. How you declare dispute, what is the next step? It's going to be that sort of stuff. So a lot of the lecture is dedicated to the processes that you will follow. But if you understand it, if you understand that we want you in the process as opposed to outside of the process, we want to get to the meat of the issue, we want to deal with it, then you will be able to cope with any of the questions that will come up in the exam. It's not a huge focus in paper 3, but there are some questions over there. if there are any other questions, then we can deal with those. The SANDF, if you do get an opportunity to run an arbitration under the auspices of the SANDF. So first of all, it's not called arbitration, it's called a court-martial. It's amazing. I had, as a candidate attorney, somebody asked me to come and represent them in a court-martial. It's a very formal setting. You walk in and, people are saluting, must you salute, must they salute? You don't know what to do. So anyway, and they run in their terms and conditions. So in the SANDF, it's not you arrived late for work, here's a warning. It's, there was a muster and there was a call and you weren't there and you weren't properly uniformed and, here's a this and here's a punishment, a demotion, they've got some unique jurisdiction there. So I ran one and it was very interesting and we had loads of fun. So if you do get to run those trials, they do come along, so once in a while, and they're terribly interesting. One of the more terribly interesting ones I did have was my guy, and this is before Dennis Davis, he smoked a joint. And then he had to get on the ship and they tested him and they found out that he tested positive for cannabis, and they wanted to dismiss him, so we got involved. We managed to get them to help him rather, which was quite weird because everyone on the ship was participating in the wacky weed. Just my guy's luck that he was caught out. But that was a court-martial, whereas in your setting, it could just be a misconduct arbitration, not an arbitration, a disciplinary inquiry. All right. If there are any questions, please raise them. So we spent a lot of time on the exceptions. Hopefully you understand that. The main thing is the CCMA arbitration. So this is an old slide because they have amended the rules. Candidate attorneys now can represent. So the CCMA has exclusive jurisdiction over conduct or capacity, which is 80% of all the disputes declared in South Africa concerns conduct or capacity. No attorneys are permitted. And no candidate attorneys ever. That was the position. Now they've changed the definition to include candidate attorneys because the need is just so great. Even though you aren't fully fledged attorneys, you mostly understand how to run trials and you can help people move along. And so, that's where it's where that amendments come in. Rule 25, so if you are an attorney or a candidate attorney and you'd like to represent the interests of your client, this is the way in which you would do it. First of all, if there's no agreement, so you, the commissioner, and the other side must all agree. So there's 3 parties that need to agree, not just you and the other side. If there's no agreement, then you apply. You can do so on the day without any papers. We don't encourage you to do that. We encourage you to at least do a bit of an affidavit for your client where he addresses or she addresses these 4 issues. The first one is the nature of the questions of law raised in the dispute. What are we talking about here? Nature of the questions of law. It could be, I don't know, the setting of traps. So you think about entrapment. In labor law, obviously, the setting of those traps, how those things are going to be regulated. These are very often things that it's fairly novel in a civil law setting. So they will talk about the nature of the question of law. Is it novel? Is it something new? The complexity of the dispute. complexity, if you've ever had a forensic investigation, they just make it so complex, this debit and credit and this and that and that. The actual meat of the issue is a complex issue, and it involves a lot of complex considerations. Public interest, perfect example is, let's say it involves a lot of actual public interest. The stuff that sort of gets the headlines these days, Tresemme, hair shampoo, whatever the story is. But let's say the guy who actually described the hair in a certain way, suddenly he's on the chopping block. And so there could be a lot of public interest. And then the last one is the comparative ability. And there was a comment on that now, is that most employers in South Africa now, they're coming through with these employer organizations. And you are quite right. And what these employer organizations are is just, a lot of them are genuine, I will say that much, but a lot of them are just lawyers. They are lawyers, they get together with other lawyers, they decide on rates, they form an employer organization, they go and market to all the employers and they say, sign up with us, and for the measly, 2,000 Rand a month, we take all your labor law needs, we'll run the trial. And what they do is they've got 40,000 employers at 2,000 Rand a month. They're making good money. And of those 40,000 employers, maybe 200 of them will have disputes. So they maybe need 50 lawyers on the staff. And these guys will run these trials until the cows come home. So there is a bit of a problem there. And to counter that, what did we do? First of all, we opened up the floodgates in the sense that we allowed candidate attorneys to come in. And there's a wonderful opportunity for candidate attorneys to pick up some of these matters where, people can't afford it. In South Africa, access to justice is determined by the strength of your pocket, except in labor law. You can do it yourself as a practitioner. You can do it as a candidate attorney. You can take it on contingency. If you just go there and you try and, okay, I'm going to run this trial. There's an employer organization on the other side. I'm going to help this person. Forget about the fees. We're just going to run this trial, and you see how you come out on the other end. Why am I encouraging you to do that? There's hardly any cost order. In my 23 years of doing this, I've only got 2 cost orders in my favor. 2 in 23 years. So costs is not a big issue. They hardly ever do they award costs. When I say hardly ever, it's 99.99991% of the time they don't award costs. Where it's frivolous and vexatious, obviously they can award costs. But in all my time, I've only ever had 2 cost orders in my favor.
Sorry.
Sure, yeah. I see it's 9:57. Is that your issue?
Okay,
no.
I just my internet broke out. If you could just explain Rule 25, just briefly.
Oh,
Sorry.
okay. Well, I've got it there. So you can also go to the rule itself. So first, the starting point is everyone. There's 3 parties that must agree: the commissioner, the other side, and you. So if there's agreement that you can represent, then if everyone agrees, then that's fine. Then you don't need to do anything else. If there's no agreement, then you apply and you use those 4 issues that I've listed there. The first one is the nature of questions of law raised in the dispute. In other words, is there any novel disputes over there? If it's just a question of, did he steal the pen or didn't he steal the pen? Well, that's a straight line. It's a foot race. So whoever's going to get there with the evidence, there's nothing novel in the questions of law. The complexity of the dispute. A typical example is forensics and that sort of stuff. Is there any of that complexity? Public interest. A lot of the time people have a lot of interest in these types of dispute. It could be actual, public interest. Let's say the guy with a Tresemme ad with a clicks dispute who described the hair in a certain way. Maybe he's on the chopping block. There'll be a lot of public interest in that. The comparative ability, which is the last one, a lot of the time the employers are coming through with employer organizations, NIASA and the like, and to balance that equation. So, you know, it's pointless going to a gunfight with a knife. You know, lawyers are going to be lawyers, and they're going to be good at what they do because they're trained, that's all they do. So to balance that equation, we're now allowing candidate attorneys in. We are dropping, you know, as soon as there's an employer organization, 9 times out of 10, I will get the right to represent the applicant. And there's just a general encouragement to take on these matters. I sent my candidate attorney the other day to go and run a trial, and she had great fun. Forget about the fees. I mean, she had great fun. She enjoyed the experience. She now knows that she can do it. So what are the odds of legal representation being rejected? It is the default position. And it's really in the exceptional cases, for example, you know, misconduct dismissal cases, there's no employer organization, your application is going to be rejected. Is there an application to appear in the CCMA? That's what Rule 25 is regulating. It's not just the CCMA, it could be the bargaining council. Say there are some statutory councils with arbitration powers. For example, the dry cleaning industry, they've got arbitration powers, and the hairdressers, they've got some arbitration powers. You have to apply as a bargaining council to run your own arbitrations, and that's fairly easily done because all that you have to do is just make sure that the bargaining councils have to go for certain training. So yeah. Okay, look, it's 10 o'clock now. Should we return at about 10:15? Is that a good time for everyone? I'm going to...
Yes, thank you.
Okay, we'll see you at 10:15. I'm just going to leave my thing on because if I do anything else, I just don't know if it's going to come back. All right, I'll see you at 10:15. Thank you.
Sir, we can't hear you. Your mic is
There we go.
muted.
How's that? Sorry about that. Okay. Sorry. It goes on to mute when I leave. So, yeah. Shall we continue? I think so, eh? Moving swiftly along. So that's rule 25. That's where we ended off. But one of the best things that could have happened in this space is candidate attorneys doing it. I tell you, a lot of people end up doing articles and they end up not actually running trials, which is bizarre. How do you know you are good at it or not good at it? And with the largest civil disputes, number of civil disputes in South Africa in the area of labor law, if you as a candidate attorney who suddenly excluded from that, you'll never end up doing labor law. So this way it just gets everyone in. My very first trial where we actually ran, not my first dispute, that was the constructive dismissal, but you know, senior counsel flew in from Pretoria. It was an unfair dismissal dispute. And in those days, before they changed the legislation, if you got dismissed for misconduct, then you lost out on all the employer contributions to your pension fund. So we wanted that money back. So that was really the focus of it. And of course, we took the point against the employer, but of course, the pension fund is another entity altogether, and that was what senior counsel flew down from Pretoria to come and tell me. There was candidate attorney, senior counsel, didn't know what I was doing. I think I was admitted or got my right of appearance, and 2 weeks later, this trial, somebody just dumped it on my lap. And it was loads of fun, lost, hands down. All the points that they took against me succeeded, including absolution from the instance. Yeah, we ran that trial. It was loads of fun. Anyway, any questions, you can welcome to come and ask me. Let's move swiftly along, shall we? Hopefully you've all got your coffee and everyone can hear me. Okay, special arbitrations. What do you need to know? So there's this thing called a pre-dismissal arbitration. Now, what is that, you ask? There is an amendment to the Act, and the amendment basically works as follows. So imagine you have a potential dispute. You're the employer and your senior manager has done something dodgy. You're not quite sure if it is or it isn't misconduct. What you don't want to do is dismiss somebody under circumstances where it's a bit dodgy, because the reinstatement costs are going to be huge. So what you then do is you have it in the contract of employment. So there's two places. There's two ways you can get it. One, you can ask them, do you agree? And if they say no, well, then you got to go not the arbitration route, the disciplinary inquiry route, appeal, and onto the CCMA. Or you can have it in the contract of employment when they start. You can say that you submit yourself, you agreed to a pre-dismissal arbitration in terms of the Act. What then happens is when there's a dispute, you refer it to the CCMA. The CCMA appoints a commissioner who basically sits as your disciplinary inquiry chairperson. Now, why would you, if you think about it, in the ordinary course, I do something wrong, there's a disciplinary inquiry. That's my first bite at the cherry. The second bite is notionally there could be an appeal, and then I go off to the CCMA and I run a conciliation, then an arbitration. What happens with these pre-dismissal arbitrations, it goes straight to the last step, which is the actual arbitration itself. So for the employer, that's pretty inviting. You want to, because you just get to cut out 4 steps and go straight to arbitration. If I win at arbitration as the employer, the only option left to you as an employee to contest the fairness is to go and review it, which is, of course, a different kettle of fish. We'll talk about that. It's a very expensive process. You know, a lot of reviews these days fail. So you could just get home. I had a senior manager at a parastatal with a pre-dismissal arbitration clause, and we ended up with Sarah Christie as our arbitrator, which was very nifty. We'll talk about the reviews a bit later on. There's a large section on that. It's, if you understand it, I don't know if it's going to come in your test, I really don't know, but if you understand it, you'll understand it forever. Reviews, both in terms of the Common Law Paja and in terms of the Labour Relations Act and what the differences are. And we'll discuss all of those things. It's loads of fun, loads of interesting fun. Where else do you get special arbitrations? In essential services. So what is an essential service, you ask? An essential service is basically there to maintain life and limb and that sort of thing. So typical example, the doctors and the nurses. You're going to say, but Mr. Brown, I saw that they went on strike a few years back, about a decade ago, more or less. How essential services work is as follows. So if you are working in an essential service, first of all, you need to be declared an essential service. Once you are declared an essential service, what then happens is that the employer and the employees need to get together to determine what are the minimum services that are needed to maintain that service. So surprisingly, think about all the various industries in South Africa. The police services, yes, they are an essential service. However, there are certain people that work for the police who are not policemen and women. They are administrators. They are declared not an essential service, so they can go on strike. But the policemen can't go on strike. And why is that important? Well, if you can go on strike, then you can further your wage demands. I want a 12% increase. You don't want to give it to me. Well, me and my friends are all going to go out on strike, and we are going to strike until such point where the employer caves in and they agree to 12%. So that's the essential equation. If you can't go on strike, it is because you are an essential service. So what's supposed to happen is you first got to define, are you an essential service? Once you are an essential service, then the next question is, what are the minimum levels of service that I need so that I can keep the service going? So if you're a doctor, for example, and you're part of a team of doctors working at Groote Schuur, and there's 200 of you, well, how many of those doctors do I need just to keep the service, keep it going? So let's say I need 100 doctors to keep the service going, working 24-hour shift. Then that is my essential service, my minimum levels, and government and the doctors will agree that they need 100 doctors. So the other 100 doctors can go on strike, but there's going to be a minimum of 100 doctors working. So 100 on strike, 100 working, and the service continues. So those are called minimum service levels. And what government tends to do is they never ever get to those agreements. They keep it all muddied up. And what happened with that big strike with the doctors and the nurses, they said, well, the demand to government was to enter into a minimum service level agreement, which they never ever did. So they said, well, if you don't want to do it, then we'll just go on a wildcat strike for a week. There were hundreds of people that were turned away at the gates of the hospital, pregnant mothers giving birth in wheelbarrows. It was terrible. It was absolutely terrible. Very quickly they cut a deal for minimum service levels, and now about 80% of the doctors have to work and 20% can go on strike, including the nurses. So that's how essential services work. But then how do you move along your wage demands in essential services? In essential services, they have what they call something called swing arbitrations. And what happens with swing arbitrations is, so you the employee party, so you the trade union, you DENOSA, or you, the police union, or whatever. That's you on the one side, and your wage demand is 12%. I am the government, I am the owner of the service, and my offer to you is 2%. So we go into the arbitration, and the arbitrator sits there and he says, right, I'm here in essential services arbitration, and I'm here to determine who's going to win. 12%, 2%, I must determine. And he makes it quite clear that those are the only two positions. You're either getting 12% or you're getting 2%. So you swing between those two positions. So when the employer realizes this, then suddenly they ameliorate their position. They go on a little sidebar with the employees and they say, you at 12, look, I can come up to about 6, but you're going to have to come down. And, you know, slowly but surely, the positions narrow from 12 and 2. Suddenly you've got between 8 and 6. So guess where it's going to end up? Probably at about 7. And that's how those essential services arbitrations happen. It doesn't happen very often because it's really just a very good strategy. It's a negotiation. So anything to do with essential services, you can't go on strike over it unless it's for something, you know, where you are maintaining the minimum service levels. And most of it will go into arbitrations. Any questions? Let's just have a quick look. Wow. Oh, it's still on the reviews. We'll get to the reviews. It's quite a long answer. But we will talk about what other CCMA arbitrations do you need to know about. There's obviously the retrenchment disputes. You can get so. Typically, a large-scale retrenchment. What do you consider large-scale? So it's anything more than 4 employees. That goes to the Labour Court. But if it's less than that, you can agree to come to the CCMA. And for single employees, where you know there's 200 people working there, there's a restructuring, one person loses their job, goes to the CCMA. You can also have CCMA disputes around your right to severance pay and whether or not the employer has calculated it correctly. There's lots of disputes around that. So, for example, you earn, I don't know, 100,000 Rand a year, plus you get parking. The value of the parking is probably worth about 12,000 Rand a year. Then in addition, on your birthday, you get cake. So that's 500 Rand extra. Then you know you might get an allowance for coming on time and time and attendance bonuses, and you add all of those things up, and suddenly you get to about 140,000. When I retrench you, do I use your 100,000 or do I use 140,000? Those types of questions. So obviously it makes a difference for things like severance pay. So you can have just a dispute just around that issue, which is terribly interesting, a Section 41 dispute in terms of the Basic Conditions of Employment Act. So yeah, there's lots of issues around that. There's a question: if in an exceptional case legal representation is allowed, doesn't that sort of limit Section 34 of the Constitution? Well, if it's exceptional and representation is allowed, like I say, it's usually if you can get to answer those questions in terms of the Rule 25. What does Section 34 of the Constitution say? Which is the other issue. So you apply Rule 25, you should be able to get in or out. It depends. So there's all of those issues. There was lots of strikes due to PPE not being given to medical workers. Yes, there were some strikes around those issues. The no work, no pay principle applied. You know, the PPE and the COVID-19. I'm the COVID-19 officer for our firm. There's supposed to be a plan, and in that plan, it's got to regulate all of those things. And if those things aren't properly regulated in the plan, you go to the Department of Labour and you lay the dispute there. and the Department of Labour is supposed to deal with those issues. Yeah, well, I don't know where that went now. Let's do that. So if that dispute doesn't get resolved properly, then yeah, you end up with strikes. Those strikes were all no work, no pay strikes. So that was another issue altogether. Anyway, I just don't know what I did to my messaging function here. I'm just sending my email address again, just so that you can email me if you want a copy of the... there's it all back. Yeah. Okay. So if you want a copy of the slides, please send me an email. Residual unfair labor practices always goes to the CCMA. These are promotion, demotion, sanctions short of dismissal, provision of benefits. All of these things go to the CCMA. So what is typically the kinds of disputes that you can expect here is things like, let's say, your performance evaluation. If you believe that your performance evaluation wasn't done properly, that's a residual unfair labor practice dispute. Let's say there's a grievance. I don't know, you don't like your colleague, the way that they, he's always very noisy, so you file a grievance and the grievance goes nowhere. Notionally, that's a residual unfair labor practice dispute that could go to the CCMA. The CCMA is going to sit there, scratch their head and wonder, just say, why don't you be more quiet? And then, you can also maybe move away, and the employer will say, well, I don't know what to do. And they'll try and guide and intervene and get the dispute going. There's not too many of those types of disputes, but notionally that's their home of those things. Because the CCMA works, they've added a whole host of other things to the CCMA jurisdiction. So, for example, discrimination disputes, where there's an employment focus. Somebody comes along and says they've been treated unfairly or arbitrarily in their workspace, and it involves an individual. That dispute could notionally go to the CCMA in arbitration. I had one recently before the bargaining council was established, where the employer, this was the allegation against the employer. The employee said he was HIV positive and needed to collect his antiretrovirals, and he asked his line manager if he could use the car to go and collect his antiretrovirals, which was outside of the area he was supposed to patrol as a security guard. He says the line manager then said, okay, you've got to start bribing me to actually leave the area so that I don't have to discipline you. And that was described as an act of discrimination. Yeah, anyway, the facts more or less were they found there was discrimination. We're taking it on review because they didn't actually serve that little, the notice of set down on us, and then they refused the rescission. We should succeed in Labour Court. But that's another issue altogether. But it's just an example of the kind of how the CCMA jurisdiction has been expanded. The nice thing is that when you get to fill in the 711 referral form, which we will get to, I'll post it. In fact, you will see that there's tick boxes, which is nice. So you get to you do get to tick the box, and if the CCMA has determines that they have jurisdiction over the matter, then they will let you, they will arbitrate the dispute, which is very useful. So they do that a lot. In fact, the CCMA can even assume jurisdiction. So let's say it's supposed to go to a bargaining council, and they can see, in the interest of justice and fairness, to send it to the bargaining council, which is in Joburg, and this and that, whatever. You just say, okay, look, we're going to deal with the thing. Oh, there, the 711 is on page 85 of your notes, which is fantastic. So the notes are fantastic, by the way, done by a guy by the name of Richard Aslop out in Durban, a very experienced labour lawyer. And the notes are really excellent. They're meant to supplement. So I'm not going through the notes. They're meant to supplement this discussion. If you read those things and you listen, if you listen intently and you participate in these discussions, that should be more than enough preparation for your paper 3 questions. No, that's what you're focused on, but I'm focused on and trying to get you interested in labour law and running these trials. So we are sort of notionally working, towards the same space. Anyway, what else do you need to know? Well, how do you know when you are dismissed? Again, just remember that in labour law, we want to keep people into a process. So we want to make it as easy as possible for them to get over the minimum. So what is it? Section 1861A, there's been a termination of a contract. Now, you are all on contracts of employment currently, contracts of articles. It's a tripartite relationship. We undertake certain things as your employer to the LPC. We undertake to expose you to certain areas of law, to make sure that you do this and do that and blah, blah, blah. But at the end of 2 years, in our firm anyway, some of you are on 1-year contracts with your firms, but at the end of that period, your contract will come to an end. It will automatically terminate. So, I mean, you wouldn't want to be in a contract of articles when you were already admitted as an attorney, for example. So it's that kind of stuff. So there will be a termination of a contract, but even that could notionally found the jurisdiction of the CCMA to inquire into whether or not that termination was fair. Failure to renew a fixed term contract, or you offer to renew it on less favorable terms, that's a dismissal. Lots of disputes around that. The perfect example of this, I appoint you on a 2-month contract. And in that 2-month, what I'm really doing is I'm checking you out. And then I'm still not sure, so I appoint you on a 6-month contract. You earn more than 17,450 Rand, and so therefore section 198 capital B doesn't apply to you. We'll talk about that in a few minutes. And at the end of that period, I still decide I don't like you, I'm going to let you go, so I don't renew your contract. Under circumstances where you've done nothing wrong, in fact, you fulfilled all the terms of the contract, there's plenty of work for you to do. Or I say to you, I was paying you 20,000 Rand a month, I think I actually want to pay you 15,000. Or I still want to pay you 20,000 Rand a month, but you can't park in the building. And you have to now park outside of the building, which means you can't work late because now it's dangerous when you collect your car. All of those types of things comes into it. And that could notionally be a case where there's a failure to renew a fixed term contract, or you offer to renew it on less favorable terms. And that's a dismissal. So even though you're still working there, if it's one of those, I'm renewing it on less favorable terms, you would accept it under protest. You'd say, okay, look, I think you're being unfair by dropping this benefit that I got before. So I'm still going to continue working for you, but notionally I can contest the fairness of whether or not you are entitled to renew on less favorable terms. So that can happen. It happens a lot. You find a lot of this stuff in the post-retirement space. Somebody goes in retirement, they work there for, I don't know, donkey's years, and then at age 65 they retire, they don't want to lose their services, so I give you a year contract. Then I renew it. So now you're 67, but now I want you to go. So then I start to say, okay, look, I'm cutting your hours, cutting your days, cutting your this, cutting your that. You know, not so easy in a post-retirement environment. It can happen, but it must happen fairly. Section 1861C, this is where they refuse to permit you to resume after you return from maternity leave. Typically, there's a lot of issues around that. People come in after their babies and everything else. In that time, they hired somebody else and now they want to keep that other person. So instead of bringing you back in, you know, give you some other menial task, you suddenly now in charge of you know, the security desk where you got to admit people, whereas before you were my secretary, now you are playing the security guard, you know, that sort of stuff. That Verniekerij can found a dismissal claim, but that's typically what we're referring to there. Any questions, please raise your hands or ask the questions. I will just keep on going until I get a question. The selective re-employment is an issue as well. So let's say there's a wildcat strike and nobody follows the right processes, and eventually after giving everyone an opportunity to explain why they should not be dismissed, I dismiss everyone. Now, but I still need the staff. So what happens is I then go and I cherry pick and I say, you and you can come back, but these guys over here that I really don't like for whatever reason, you can't come back. So that selective re-employment, that could be a dismissal. A lot of employers, especially larger employers, they tend to make that mistake. Doesn't happen very often, but it does happen. Section 1861E, this is where continued employment is made intolerable. We did talk about this. This is the constructive dismissal claim. That could be found jurisdiction of the CCMA on the contestation of the fairness of the dismissal. Section 197, transfers of employees. This is where the employees receive substantially the same, but there are major differences, let's say. Perfect example, the ambulance service. The ambulance service, believe it or not, in Cape Town was run by the City of Cape Town on an agency basis on behalf of the province. So way back when in the day, the City of Cape Town as a municipality had defined borders, and they invested heavily in their ambulance service because, you know, there's this thing called the golden half hour. So if you have an accident, let's say in Main Road, Rondebosch, well, I guarantee you the ambulance service is going to get to you within a half an hour and your life is going to be saved. Outside of the jurisdiction of the City of Cape Town, the problem was that the golden half hour was more like a golden 45 minutes or a silver 45 minutes. And on the West Coast, it was like, you know, a bronze hour. You know, it's hardly ever got there. So there was this unequal service throughout the province. And because it was a provincial function, the province then said, I'm taking the service back. I'm going to take the service back and I'm going to run it. So thank you, City of Cape Town, for running the service for 100 years on my behalf. It's now a provincial function. And that way they took all the city's resources and they just basically flattened it and spread it out to the edges so, you know, they could get more of a service going. But therein lied the difficulty, because the City of Cape Town had very, very good benefits, whereas the province, they had different benefits and they weren't as great. So that was the scenario. So the first thing they said is, well, that's a 197 transfer, and it took them 20 years to negotiate that equalization of those benefits. And in that time, the province had to continue paying the benefits to the ex-City of Cape Town employees. Yeah, they eventually got to agree. But that was the only way out, because if they had to just force it, then that would have been a dismissal, and probably an automatically unfair dismissal, and that would have cost the province a lot of money. So here's a question scenario: employee referred an unfair labour practice dispute in respect of demotion. That goes to the CCMA. After conciliation, the employer decides to make false charges. Well, you don't know the charges are false, but let's say, and they justify dismissal to dismiss the employee. Does the employee have to withdraw the unfair labour practice dispute? No. And refer the dismissal. One or both matters can be arbitrated simultaneously. Yes, they can. You can apply to consolidate. Employees only want compensation and not reinstatement. Well, that's a bit short-sighted. You know, it's, if you ask for reinstatement, you do know that that's what the employer doesn't want. So it does tend to increase the offers of settlement. Here's a thing here about endurance. Yes, you know, it is so that over the years, the level of the service has eroded. It's an expensive service. Each of those ambulance trucks, you know, even the small one just doing patient transfers can cost up to R1 million just to kit out. So that major big ones, the emergency responders, that's like $1.5 million. The personnel in there, super duper trained, you know, easily $500,000 per senior ambulance personnel. So it's a very expensive resource. But yeah, you know, there is no reason why we as South Africans should, if I have an accident in Main Road, Rondebosch, it should be the same as if I'm having an accident in Durance. The level of service should be the same. But it is so that golden half hour, if an ambulance gets to you within a half hour of that accident, you're probably going to survive. But yeah, it's another issue altogether. We're not here to talk about that inequality. Any other questions around these 197 transfers? They can be pretty interesting because the issue is, let's say our two firms merge. We've got Discovery Health, you've got, I don't know, Oxygen. Is that the benefits or the conditions of service, are they substantially less favorable? We then have to compare Discovery Health to Oxygen, and we're going to say, they're more or less the same, so that's a neutral requirement. But if it's a question of we've got Discovery Health and you've got nothing, well, you know, that's now a big issue. So us coming over from Harold Geen to your firm where there's nothing, that could be the sticking point, and that could mean that that's a dismissal. That's the concept that I'm trying to get across. I hope that you get that as a concept, because that's really what Section 197 is aimed at. Moving swiftly along, if there are any questions, even about the old sections, you're welcome to raise them. It only really works, you know, a lot of learning happens with the questions. So here is the issue. And there is going to be a question around this when we, for the break. So, then of course, a physical dismissal, in other words, you know, there's no afskeid partake, you must say you're leaving now or anything like that. You could still notionally be in employment and have the right to contest the fairness of whatever's happened to you. Well, there's a request to repeat Section 197. Let me go back there and try and just get it in there. So what happens is that where there's a transfer of a business as a going concern, and the differences between the old employer and the new employer is substantially less favorable terms and conditions of employment, then that could found a dismissal claim. So even though you move across, but because you were on medical aid and now there's no medical aid, you then say, well, that's substantially less favorable, and that amounts to a dismissal. So you could still be working there. The CCMA, eventually Labour Court gets involved, and they say, no, that is less favorable, and orders that the old employer must pay compensation, or they could order that the conditions of service must be reinstated. There's a whole host of options available to them. But that's the concept that I'm trying to get across, is that you can't just take over people's, their businesses and not give effect to it. Some more interesting stories around Section 197 at UCT. UCT decided that they've got these tremendous benefits. We'll deal with the retrenchments now. If the retrenchment is in anticipation of a 197 transfer, then it could be a problem, and it could found an automatically unfair dismissal claim. So typical example, let's talk about UCT. The professors and the associate professors and all the people working there, they can send their children to UCT to study and pay something like 20% of the fees. So imagine, you know how much your degrees cost you. Imagine your dad worked at UCT and you had to pay 25% of the fees. It's a huge benefit. UCT eventually, over the years, they calculated what that benefit costs, and they decided we actually just want to keep it for the academic staff and for the admin staff. So the custodial staff, like cleaners and that sort of stuff, they thought, let's try and not extend it to them. They came up with this idea they're going to outsource the service. Appoint, Bidvest cleaning services. So they took the cleaning service, they put it out to tender. A whole bunch of people tendered for the cleaning services, and as a result, let's say Bidvest won. So UCT then said, okay, we appointed Bidvest, and they went to all their cleaners. They said, we've outsourced the service, so unfortunately we have to retrench you. They said, no, you've actually outsourced the service. It's a Section 197 transfer. We go across. There was a Labour Court decision that said, no, that's right. Those employees go across. Now, obviously, Bidvest had bid, 17 Rand an hour, and suddenly they get 200 cleaning staff coming from UCT, where the average hourly rate is, let's say, 45 Rand an hour. So all of a sudden, this was now unviable. So Bidvest went back to UCT and said, here's your contract, we can't afford to keep these people. So UCT then said, okay, we're going to go out to tender once again. So everyone was now working for Bidvest. And UCT said, no, you keep them, you retrench them, we'll pay the retrenchment costs on your side. They said, nope, back to court, second generation transfer, went from Bidvest back to UCT, from UCT to whatsoever service provider. And all the time they were protected by 197. So UCT can do whatever they like. The service will come back to UCT and go to whomsoever, and the terms and conditions will be protected. So that's the power of Section 197. Nobody lost their jobs. They all went over to the new service providers. They just got managed by somebody else as opposed to UCT, and their terms and conditions stayed intact. Obviously the push from UCT or the plan was, once they had Bidvest, they encouraged Bidvest to place those staff members elsewhere at other clients. And so get them safely ensconced in that way, and hopefully in that process they get to dilute their focus, and they don't want to then come back to UCT because they got a job on their doorstep or something like that. So that's the power of 197 transfers. A lot of the time, the employer wants to get rid of things, get rid of employees. So in anticipation of the 197 transfer, they tell nobody that there's a 197 transfer going to happen. They just start restructuring, and everyone's sort of, well, this is crazy. And then eventually when the 197 transfer happens, that makes no sense. They go back, they fetch all those people that were retrenched, bring them into this dispute, automatically unfair dismissals, because it was in anticipation of the transfer. So it's a very dangerous area. Don't mess with it lightly. And certainly it's one of the areas that is always being watched, because people are always trying to finagle. I don't think that's going to be the basis of the question in the exams, but it's terribly interesting, and it does bring over the concept that what we want to do is to preserve those terms and conditions of employment when they move from the one employer into the next employer. Once you land on the other side, I can then start to negotiate to try and get the terms and conditions the same. So that's all useful. Any other questions? No? Moving swiftly along. So, misconduct arbitrations at the CCMA. 70 to 80% of all the dismissal disputes will concern conduct or capacity. It's the bread and butter of all labour lawyers in South Africa. You've got to understand these things to be able to make a go of it. To help you, the Labour Relations Act and the government decided that they're going to publish a code of good practice, which is Schedule 8 to the Labour Relations Act. And it is not mind-blowing in the sense of it introduces new concepts. The resolution of any disputes in South Africa, as an arbitrator, what I have to do is I've got to hear both sides. If I'm a disciplinary inquiry chairperson, I've got to hear both sides. The audi alteram partem rule, that is what is the focus of the Code of Good Practice. So at a very general level, audi alteram partem gets you home. What is audi alteram partem? Literally to hear both sides before you make a decision. Now, every single case in South Africa is founded on two legs. One is the process and the other one is the substance. So the process is audi alteram partem and the substance is, well, whatever it is that I'm upset about. So it could be that somebody has stolen something, a stapler. That's why I'm upset as your employer. That's the reason why you are facing this process. I would charge you with theft of a stapler. I would describe the time period when this stapler went missing and was found in your possession. And I will say that that's theft. And you, as the employee, well, you can come along and you can say, I didn't steal it. I put it in my bag. I took it with me to court because I needed to go paginate the court file and I needed the stapler to make sure that I could staple everything. And my intention wasn't to steal it. It was to bring it back. Now, I, as your employer, I must sit there and make the decision as to whether or not that's misconduct or not. So what are the kinds of stuff that's going to help me as an arbitrator or a disciplinary inquiry chairperson? Maybe there were rules specifically around the removal of the stapler. Just to emphasize, I could put a sign up behind me that says, don't take the stapler under any circumstances. And if you broke that rule, well, then it's not that you stole the stapler, it's that you broke my rule. That would then found the basis for that misconduct inquiry. But the process is always the same. You've got to know more or less what it is that the employer is upset about. So here's an inquiry charge sheet. In there, I tell you more or less what I'm upset about. And then you have the chance to answer those allegations. So as per usual, you can confess, you can admit everything. You can say, yes, I did take it. You can avoid the consequences that comes with that admission, but I did take it, but I had to do this and that in the court file and whatever. Confess and avoid. And of course, you can deny it. You can say it wasn't me. So-and-so put it in my bag and then, you know, they set me up. You can go with that defense as well. So I've got to tell you why I'm upset, and I've got to give you an opportunity to answer those allegations. Answering the allegations, you can bring evidence. You can bring documentary evidence. You can bring a recording of, you know, you just so happen to record this guy doing this stuff, whatever. And that's your evidence. Everything gets ventilated in the inquiry and we move on from there. It is, however, so that the larger you are as an employer, so let's say you're the City of Cape Town, you've got 35,000 employees, you can imagine that those proceedings are going to be fairly formal. There's probably going to be a recording, there's going to be a written a charge sheet, there's going to be the opportunity for you to be represented by a trade union. You can ask for discovery of the documents so that you can prepare. It's going to be a fairly informal sort of, it's going to be a sort of a fairly formal process. The recordings, when I say recordings, those of you who are making notes, you are recording this discussion. Do you have my consent? Well, no, but do you need my consent to do that? If I know that you are recording it, like I can see right now, these proceedings are being recorded, and I object to it being recorded, well, that's an issue. But most times, you know, there is no consent required, but if it is so that you're making a surreptitious secret recording, then that could be a problem for you. There's the Interception and Monitoring of Electronic Communications Act, and that makes it a crime to record under certain circumstances. But at a very general level, if I'm making notes, I'm recording it, so there shouldn't be an issue. So if I come along to the meeting and say, I don't want to make notes, I'm actually just going to record the discussion. On what basis can an employer possibly say no? If I can make notes or I can record it, even if they say I don't agree to the issues being recorded, you say, well, you know, stuff you, I'm going to record it. So I don't trust you because you are inaccurate whenever you relay these things back again. But if there's an expectation of privacy around the recording, so, you know, most people would agree if you go to the toilet, well, you know, employers have no business recording what's going on there. I have an expectation of privacy, or it's a without prejudice discussion. Without prejudice and off the record means exactly that. Off the record, which means no record. So that's how those things get regulated. But at a very general level, if it's relevant, it's admissible. It's not criminal court. If it's relevant, it's admissible. And then it's just a question of, well, was it done in violation of your constitutional right of privacy, expectations of privacy, all of those things. And 9 times out of 10, if it's a major issue, then, well, you can get it excluded. But if it's a question of, well, I told them I'm recording and they said no, and I said, well, stuff you, I'm recording anyway, that's going to be admitted because it's the same as writing it down. But when it comes to the regulation of this kind of evidence, you'll be surprised to see that this is not a question that gets raised very often. But when it does get raised, the tendency is to try and include it because the information is relevant. And if the information is relevant and goes to the issue, then it's there, then everybody can deal with it. It doesn't mean that there's special rules around the law of evidence. It's just that in labor law, we want to get to the meat of the issue. So the tendency will be to allow things in as opposed to not allow things in. But I was talking about the procedure, especially the City of Cape Town. You can imagine a big organization like that. There would be a bigger focus on the process and the rights of employees. But let's say, and this is a true story, you're a little two-person operation, you're selling fish and chips. You know, this is more or less what happened. It's a mom and a dad. They're running a little fish shop out in Long Street. Dad goes to go buy stocks. Mom then tells the fish fryer, who's a large African male, what to do, and he takes exception and he shouts at her and he says, "You don't dare talk to me like that." And of course, Mom is so upset, she starts crying. And at that moment, Dad walks in. And Dad says to Mom, "What's going on?" And Mom says, "This is more or less what happened." So Dad goes to the fryer and says, "This is what my wife just told me, that you shouted at her and said, don't talk to her like this and da-da-da-da-da. Is that right?" And he says, "Yeah, I did shout at her. I did tell her, don't talk to me like that. I'm not some small child. You know, you've got more respect for me because I'm a male and you're a female," that sort of stuff. And the dad then took a look at it and said, "Look, I can't have you shouting at my wife. You have to leave. You have to get out." So it went to the CCMA. My daughter took it on, went to the CCMA, and the CCMA said, well, at a very general level, that was ad alteram partem, and the information was confirmed. So they ruled that dismissal fair. But you'd never get away with that in the City of Cape Town because you're a large employer, you have more resources, more is expected of you. So you've got those two sort of polar positions where the smaller you are, the more you can get away with. The larger you are, the harder it is for you to get away with. But at a very general level, the point that I'm trying to make, or the understanding I'm trying to impart, is that the process in the Code of Good Practice focuses on the ad alteram partem, hearing both sides. Do you know what the issues are? Did you have an opportunity to respond to it? And what was the finding? Was the finding consistent with the information that was presented? Probably going to be fair. Where the unfair dismissal claims come in is obviously where it's not so, where I present a defense. No, it wasn't me, it was somebody else. Or they rely on, and this happened, I just couldn't believe it in this day and age, but they relied on a polygraph examination. There was no other evidence, only a polygraph. Of course, we won that case and we were handsomely rewarded. But you can't do polygraphs and just rely on the polygraphs. So here's a question. Do I need to repeat the questions, or can everyone see the questions? I suppose everyone can see the questions. So 197, permanent staff members, contract staff members treated the same way. So obviously permanent staff members have been there longer, they've got the benefits, whereas contract staff don't. You can't just, if you're appointed on a 2-year contract and in the middle there's a 197 transfer, you can't just suddenly say, excuse me, all the contract staff members are terminated because they've got contracts. It's an unfair termination. So that's a failure to renew or early termination of a fixed term contract. That would certainly found a unfair dismissal claim. The next question is, if someone purchases a business, totally new owners, coffee shop, that sort of stuff, is there regulation of how they need to deal with the existing staff, or they're taken over on the same basis? That's exactly what Section 197 is meant to guarantee, is that your terms and conditions vis-a-vis your old employer is the terms and conditions of employment vis-a-vis the new employer. And they both are held equally liable. So if anything does go wrong, you can sue them both. You don't get compensated twice. It just means that one of them will have to pay for that. But that's what 197 does. It prevents a situation where your hard-fought, hard-won right to, I don't know, start at 8 o'clock in the morning, it's in your contract and this, that, and the other, and now to get rid of it, all I have to do is sell the business and buy it back. And in that process, your rights just dissipate. You can just see how unfair that is. It just lends itself to verneerkerij. So 197 is there to try and protect those terms and conditions and prevent those things from coming to the fore. Any other questions around this stuff? So yeah, let's. What else do you need to know about the Code of Good Practice? It talks about the progressive application of discipline. So if somebody comes late, for example, is that a dismissal? So, you know, the dismissal could be warranted if it's your 6th time you've come late. And I've given you warnings every time. So that's progressive application of discipline, or first warning, second warning, that sort of stuff. But if it's egregious enough, if the substantive reason for the dismissal, you know, let's say it's theft. Theft always destroys the very fabric of the contract of employment, any sort of dishonesty. So it could found a dismissal even for a first offence. But if it's things like, you know, I came late or I wasn't properly attired, you know, you'd probably go through a few warnings before they'd be entitled to dismiss. How does the compensation for early termination of a fixed-term contract work? Well, it works as per usual. Compensation is what must be appropriate in the circumstances. Whether it's a fixed-term contract or permanent contract, compensation would work in the same way. It's compensation for the loss of office. If you are in month 1 of a 24-month contract, does that mean that you can get the balance of your contract? No, it's compensation. You've only been there for a month. If it's a fair dismissal, or you know, it's a dismissal for misconduct or something like that, the fact that you got 23 months left on your contract is neither here nor there. So the thing to do with a 23-month balance of contract is to ask for reinstatement. That would make more sense. So let's say you get dismissed today. Today is the 23rd. By probably the middle of November, your arbitration would be done and you get reinstated. So you get that 6 weeks. That's all you'd get, and then you get to work. If, however, it's your last 2 months of the contract and you get dismissed and it's a spurious thing, and you get compensation, you could get 6 months compensation, even though you've only got 2 months left on your contract. They're not going to limit the compensation such as that, because it's compensation for loss of office. The length of your balance of the contract is neither here nor there. It's not a contractual claim. It's an unfair dismissal claim. It's the equity jurisdiction of the Labour Court. There's questions. So I've answered that. Can you only be compensated for what is left? No, you can't. You get compensated for your loss of office. If the dismissal is fair, both procedurally and substantively, you get nothing. If the dismissal is procedurally unfair, you're going to get less. If the dismissal is substantively unfair but procedurally fair, you'll get more. But it's within the discretion of the arbitrator. At a very general sort of level, for a procedurally unfair dismissal, you're looking at a rule of thumb of about 4 months. Don't quote me. It's a rule of thumb, literally the length of my thumb. It's that type of thing. There's nothing that anybody can do around the arbitrator's discretion around that. If you believe that you should have got more compensation and you take it on review, the Labour Court's going to say, well, it's within the discretion of the arbitrator. He decided that, so I'm not going to mess with that. Do these types of disputes prescribe, or any labour law disputes actually, i.e. is there a time period within which to lodge a dispute? We will deal with that, but okay, well, let's deal with it now. So remember, the very first slide is that we said we want the fast, efficient and cheap resolution of labour disputes. So the only way to do that is to get people into the system as quickly as possible. So what we do is we say you get dismissed today, well, you've got 30 days within which to refer your dispute. So let's say you take 31 days. Has your claim prescribed? No, it hasn't. It's still a common law basis. You've got 3 years to dispute the fairness, all of those kinds of things. All that you are restricted from doing is you can't now use the CCMA jurisdiction any longer because you took too long. Does that mean that that's the end of the matter? You now, must go sit in the corner and that's it? No, you can apply for condonation for the late referral of your dispute. And condonation is regulated by the normal rules. You've got to describe you've got to mechanically calculate the length of time, or how late are you? What are your reasons for it? Your prospects of success and the balance of convenience. And once you apply, it will be judged on those merits. So what if you got dismissed on the 23rd of September and you only referred your dispute on the 23rd of December? You can apply for condonation. It's just that now you have to provide more of a reason. So people that got dismissed in about March and they were faced with COVID-19 and there was some uncertainty, a lot of those disputes are coming to the fore now and they are being condoned. But let's say it's today and you twiddle your thumbs and you come after 35 days and you've got no real prospects and no real good reasons, they're probably going to turn you down. So the 30 days from the date of your dismissal is critical. So just to help you along, because now you're worried, what if I send or refer my dispute, am I still going to get paid my notice pay? So you wait until the last day on which you get paid. So let's say you get paid at the end of the month. So then on the 1st of October, I'd expect you to refer your dispute if that was an issue. But let's say I'm your employer and I want to veneer you. I want to mess you around a little bit. I say I'm only going to pay you at the end of October. That way I know I dismiss you today. Come the end of October, more than 30 days have passed. So to help you out, Labour Relations Act says date of dismissal or 30 days from the last day on which you were entitled to receive your payment. Because a lot of employers mess around with that. But in the main, it's 30 days. They want to get you into the system. If you get dismissed today and you refer your dispute on the same day, you will get a conciliation date within 3 weeks of today, which is somewhere in the middle of October. If the conciliation fails and you then refer it to arbitration, you will get your arbitration date in about the middle of November. You tell me any other area of civil disputes that will get you in and out from start to finish, done, dusted, trial run within 6 weeks. Any other area and, you'll get, you'll win this prize. But it just doesn't exist. Labour law is the only one that can take you from start to finish in about 6 to 8 weeks. There's a little bit more delays now because there's lots of large-scale retrenchments coming through and the personnel are thin on the ground. But it does happen a lot of the times, start to finish 6 weeks. It's amazing. So yeah, if you miss your 30 days, you still go to the CCMA, you apply for condonation. There was somebody that applied for condonation 270 days after their dismissal, and they got it because they could provide compelling reasons as to why they didn't go immediately to the CCMA. With such a large delay, the tendency is to turn it down, but in this case there were all kinds of technical issues And so they condoned it. They said you can bring your dispute. Now, why is that a bad idea at a very general level? Because labor law, as you can see, if you're a small employer and you don't run and you don't record things, and you just keep very rough notes, it's a very sort of robust process. After a year, how are you expected to defend that dismissal? I'll ask you this question, which is how you store the information in your brain. Did you lock your car last night when you pulled up in the driveway? You'd probably be able to remember locking your car. Can you remember locking your car in August last year? You have no specific recollection. Something unusual would have to happen. So what we tend to do is we fall back on, I know that I locked my car because I always lock my car. But you don't have a specific recollection. I have a recollection about picking up this glass, drinking the water. You can remember it. You can ask me questions about it. But in a year's time, hey, you can't ask me that. So that's the problem with labor law if you're going to take too long. So we encourage you, go, get in there. That way the stuff is still fresh in your head. You can probably still remember what happened. But if you are late, go to the CCMA anyway, ask for condonation. If it's granted, great. If it's not granted, you haven't dealt with all of the requirements properly. And the main one is the reasons for the delay and the prospects of success. If you can get those two dealt with, then good prospects of success will make up for a long delay and poor reasons. But poor reasons with poor prospects of success is probably going to be turned down, even if it's for a short period. Any questions around that? This isn't really a lecture about condonation, but you should be able to know how to deal with condonation in the normal course. But condonation is a possibility within the labor law context as well for the late referral, especially if it's an unfair dismissal cases. What else do you need to know about arbitrations in the CCMA? Arbitrations in the CCMA, the law of evidence is essential. Doesn't mean that now the law of evidence is out the window. You can still object to things like, prior consistent statements. All of those types of things is all still available to you. Just remember that this is a civil context. It is not a criminal context. So this is on the balance of probability as opposed to beyond reasonable doubt. So a lot of the stuff that's available to you in a criminal context is not available to you in a civil context generally, and it's certainly not going to be available to you in the context of an arbitration. So just be aware of that. It's basically still a trial with a minimum of legal formalities. So an arbitration is a trial with a minimum of legal formalities. So typical example, my example on the 711 where I said the alleged unfair dismissal of the applicant by the respondent employer. What's that about? Well, during the opening address, at 2 minutes I will more or less define what the issues are. And even if I come along and I say, this is all about parking, and it turns out that it's not about parking, it's about obeying the rules. That is what the issue in dispute is. The arbitrator, regardless of what you describe it, they can ignore that description. They can say, this is about the rules, Mr. Brown. There was a rule up on the wall that said, don't park in the CEO's parking bay. You park there, and that's why they disciplined you. It's not got to do about parking. It's about the rule. So minimum of legal formalities, and minimum of legal formalities, this is where lawyers tend to bedevil the process. They are hated by arbitrators, actually hated. They hate lawyers because lawyers bedevil the process. So if you go in there and you don't bedevil the process, in other words, take all these points in limine and everything else that goes with it, you'll be fine. But if you do, you'll bedevil the process and you won't be liked. So minimum of legal formalities, so discovery, forget it. Forget it. You get your bundle on the day. You get the other side's bundle on the day. You're expected to run that trial. That's how it goes. You roll up your sleeves, you get stuck in, you start leading the evidence, and that's what it's about. Doesn't mean it's chaotic, because obviously you still have an opportunity to prepare with your client. So you know more or less what the issues are. If you come there and you expect the issue to be around the sign that was above the CEO's parking ban, the parking, and the documents that they discover is your medical history, and you say, well, here's something strange going on here. This is the case we're bringing. I don't know what the medical history's got to do with things. So it's that kind of process, and I can't emphasize enough minimum of legal formalities. So all those things that's available to you in the High Court and that sort of stuff, not available to you now. It's minimum of legal formalities. They're just going to get they're going to get on with things, and they're going to get very irritated with you if you bring all kinds of extraneous stuff. Yesterday we ran a 2-day arbitration in the Northern Cape. So we in Cape Town ran it in the Northern Cape via virtually. My opponents were sitting in Johannesburg. The issues in dispute was all around a fair suspension. So it's a residual unfair labor practice dispute. And they brought in this witness that had nothing to do with any process, wasn't even an employee, it was a contractor. And, it was just, they are going to get a hiding in that matter, a proper hiding, because they brought irrelevant material. It had nothing to do with the issues that were identified as being in dispute. And in that matter, just so coincidentally, we had a pre-arbitration minute. So we took the time, trouble and effort to sit down with the other side, go through the evidence, say this is admitted, this is not admitted, this is an issue, this is what the arbitrator needs to decide. And despite doing all of that, they still brought this irrelevant witnesses that, and the arbitrator just sat there very patiently, said, right, Mr. Brown, we understand that this is irrelevant or maybe irrelevant. I have to hear it because this is what the employer wants to bring. And they heard all the evidence, and we cross-examined this guy on his views about all kinds of things, which was had nothing to do with the suspension. So we expect a handsome payout there. Again, it'll be compensation. They did dismiss my guy subsequently, but if he was still working there, that compensation would happen even though he's still working there. So that's also important. You don't need a complete termination to be able to go after them. It's a very useful area, and it's one of those areas where you can still basically litigate and retain your employment. Terms of address, Mr. or Madam Commissioner, it's very informal. You sit down. Most of the time, the actual physical arbitration venue. It's typically what I'm sitting in here. You have a look. It's just me in a room. It's a table. It's very easy. It's nobody's, the Law Society, well, now the LPC, they said we must wear a tie. So a lot of the times you can judge, you can see immediately who the lawyers are because they're wearing a tie. Most of the lawyers go there, they don't wear a tie. There's no robes. There's no nothing. You just go there. Don't pitch up in your slip-slops and your slippers. But if you're a trade union, you can actually pitch up with your slip-slops and your slippers if you so wish. It's not about what you look like, it's about what you've got to say. So it's very robust, and they get on with things. So if you've got any questions around the actual arbitration process, you're welcome to raise those. But at the very general level, minimum of legal formalities, no gowns, don't be surprised, and there's no postponements there. You get there and you say, well, I didn't have a chance to read this bundle of documents, Mr. Commissioner, can I get a postponement? The answer is going to be, take 10 minutes, read it, we are running. So that jurisdiction of the arbitrator set out in section 138 subsection 1. The arbitrator must determine the disputes fairly and quickly, dealing with the substantial merits of the dispute with a minimum of legal formalities. What is the substantial merits of the dispute? Well, they will determine that based on what the parties agree as being the issues in dispute. It's very robust. You can agree on the day that this is really about a sign above a parking spot, and whether or not you saw the sign or you obeyed it, all of those things. So it's one of those processes, minimum of legal formalities, substantial merits of the dispute, regardless of what the employee has classified the dispute as. If I'm the arbitrator and he said it's about, the second coming of Jesus Christ, and I read it and I say this is about the sign, then it's about the sign, regardless of what he put in his 711 referral form. He's here, I must deal with the issues. Mr. Employer, you know what happened because you dismissed this guy. So that's how they'll go. Anyone run an arbitration? Can anyone back me up in terms of their experiences at the CCMA in terms of how these arbitrations go? It's a really encouraging environment. I would certainly encourage everyone to try and run an arbitration at the CCMA, and I would try and, because there's if you lose, there's no cost order unless your defense or your claim was frivolous and vexatious. Like I say, 23 years, I've got 2 cost orders in my favor. So there's going to be no cost. So it's almost risk-free litigation for you. You can take on a matter, you can pick it up from various sources. There's the South African Society for Labour Law. You can go and write to them and say, I'm a candidate attorney, we don't do labour law here, but I'd like to run a labour law trial. Please can somebody that comes to see you, it's basically like an advice office, send that dispute to me, I'll take it on. It could be somebody from the community, can you help? And then you help and you see what you can do. You get your ass kicked, it's fantastic, but there's no cost order, but you've run a trial, you understand more or less what that process is. So I would certainly encourage you to do it even during your articles. If you want to make a career of it, obviously that's also available to you. The more you do, the better you get. We can move on from there. So here's where you would be required to refer a dispute. So there's the CCMA website. You go to that website, you can get all the forms that you would ever need. So the 711, there is a 7.1, there's a 7.2, and all of those things. You can actually download those forms if you need it. The name of the association, there are several out there. I belong to an organization called SASLaw, the South African Society for Labour Law. Now, it's not for labour lawyers, it's for labour law, because arbitrators from the CCMA also belong to SASLaw. Trade unionists belong to SASLaw. We're a society dedicated to, what happens within the labour law context, the processes, the latest cases, where's it going? So you can apply to join. There's discounted rates for candidate attorneys, and for trade unions, I think it's free, or 80 Rand a year or something silly like that. But it's really useful. You go to seminars, there's webinars, there's all kinds of resources that's available. One of the things we do as the South African Society for Labour Law is we run at the Labour Court. We staff an office, and on a Friday, people can come and see us and get advice. And a lot of the time, we take those matters on. We help them. There's no chance of us getting any fees because they really sort of legal aid candidates, but it's useful. The reason why you became a lawyer was to help people. And labour law gives you that unique opportunity. Hang the fees, whatever's going to happen is going to happen. And you run that trial, and it's very useful. And there's nothing more rewarding than looking somebody in the eye after you've given them advice and you've really helped them. Labour law gives you that opportunity, especially when you're acting for employees. If it's an employer, well, they should be able to pay. The more you do it, the better you get at it. And, you know, one free case means probably 10 paid cases, because, you know, you're going to be able to pick up, be more discerning about what you can pick up and what you can't pick up. So we at Heraldry, we encourage our CAs to take on these matters, to come get the guidance and run the trial. It's loads of fun, no costs, it's only your time, and the experience is invaluable. So if it's available to you, then fantastic. You want to get the form, 711 referral form. This is to refer the matter to conciliation. So you're immediately going to ask, somebody's going to ask the question, what about con-arb? So con-arb is one of those special processes. Con-arb is conciliation followed immediately by the arbitration. Why do we do this, you say? Why does con-arb exist? So imagine your 6-week time frame. It's actually now could be truncated to about 3 weeks if you allow con-arb. So conciliation followed immediately by the arbitration. What we found is that a lot of employers stopped pitching up for the conciliation. So they just didn't even bother sending anyone to the conciliation. And then what had happened, everyone is there, the whole thing's been arranged, and the employer isn't there. So the employer says, no, we're not coming. So they issue the certificate. And once the certificate is issued, you can then go and use the next one on that list, which is the 713 form, and refer the matter to arbitration. So the matter's now at arbitration, and along comes the employer, and now they want to settle. You see, because they know they've got a crappy case. So yeah, now they want to settle. So this way, when we have a con-arb, it forces the employer to pitch. And if they are going to settle, they're going to settle. If they're not going to settle, well, then they'll probably postpone the arbitration portions so that, you know, you can have a proper dispute. So there's a question here about someone that's retrenched. Well, the thing about labor law is that somebody's always short of money because they've been dismissed. So that's always the case, and contingency is something that they do encourage you to do because it's a way of getting paid. You get your 25% on a contingency fee basis or whatever the story is. I don't do too many of them these days, but I know they exist. And if it's not a question of, well, you know, how much money, it's just a question of, well, what are the issues in dispute? Do you trust, do you back the issues? You take the instructions from the client and say, I can just don't see it. I'm not going to take contingency. So that happens all the time. What would be the reason for objecting to the con-arb process? So if I'm going to be involved, then I can't in this situation because my time is valuable. So because I want to control the process, because the conciliation, if you get dismissed today, referred today, you'll get a conciliation within 3 weeks. So I might not be available, I might be doing something else. So I will object to the con-arb from the start. When I refer the dispute already on behalf of my client, I'll say, we don't want con-arb, we want conciliation, and we want arbitration thereafter. But that's to suit me. Most employers don't like con-arbs because they actually do have a defense. So let's say I'm looking forward to running this trial. My ex-secretary has taken me on and made all kinds of spurious allegations against me. I want to run that trial. I want to clear my name, but I want my lawyer there. So I'll go to conciliation, but I want to properly prepare for the arbitration. I can't come to the conciliation with my 6 witnesses because that con-arb will be for half a day, and my 6 witnesses could take 2 days. So because I want to control the process, so that would be some of the reasons why I'd object to the con-op. But in the main, most of these disputes coming through the CCMA, where there's hardly any lawyers involved, they're going for con-op. And con-op puts pressure on the employer to actually prepare and come there with an offer and get things done. So it's not a bad process. I don't like it myself because it means I'm going to be unprepared. So I tend to object. I'm going to move the slide away now, but I hope you all got that CCMA email address. Jurisdiction of the Labour Court, we have dealt with this. This is just to remind you that dismissals based on conduct or capacity, residual unfair labour practices, single employee retrenchments, and they have added to it with the tick box system. If you tick a box, well, the CCMA will deal with it. This is the section where we're going to deal with section 189. So before I move off onto this section, is there any other questions that you have? We have been running for about, what's it now, an hour and a half. Do you guys want to take a quick break? Or are you good to go? We can come back at 12 o'clock and then push on till just past 1. And then by the time we come back, we can finish off and try and get it done just after 2. Okay, so let's take a 15-minute break. It's now 11:45. Shall we come back at 12? You all good with that? Okay, see you at 12. I'm just going to leave things on again. And when I come back, I'll check that my mic is working. Okay, see you at 12. Okay, and I'm back. Hello, everyone. Are you back? It's very hard to tell.
Yes, we are. Yes, we are.
Okay, good. Oh, that's easy enough. Let's crack on, shall we? Where are we? Okay. Operational requirements dismissals. What do you need to know? So obviously, it's all about Section 189. This is the basis. Even if it's a large scale retrenchment, Section 189 capital A, 189 is the consultation topics. So when we talk about these consultation topics listed in Section 189, they typically deal with things that you'd expect to deal with. So it's stuff like, what is the reason for this restructuring? Now, this is easily explained usually, but it's important to delineate the reasons for the restructuring and then discussing the impact of the need to restructure on everyone. So the impact is what the topics deal with, and the starting point is always the reason. So why is it that you need to restructure? So operational requirements relates to the financial, technological, or operational needs of the business. Now, in this day and age, you can imagine a lot of people's incomes have been devastated by the COVID-19 lockdown regulations to prevent the spread of COVID-19. A lot of businesses are still closed, such as nightclubs and the like. Now, imagine you, a nightclub owner, and your landlord is pushing you for money. When are you paying? You can't open up, so you can't, a lot of things that you can't do. Besides the whole impossibility of performance, arguments that go with it. As a nightclub owner, you have no income and you're probably facing closure. So what is the reason for this need to restructure? It is financial. We would all agree. Just because the employer says it's financial doesn't mean you can't inquire into it. So what we typically do is we say, oh, financially, is it? Well, let's see the finances. I give you all kinds of confidentiality undertakings, but I want to see what the finances are. I want to see how much the CEO is earning, the CFO, where else we can save money, that sort of stuff. So think typically SAA. Does anybody understand what happened at SAA? It's a very crazy situation. They need 10.1 billion to continue operating. From the outside looking in, I want to ask, well, why do you need so much money to run an airline? Why can Comair do it on a smaller scale, but for much less money? So the finances over there is going to be an issue. It's going to be one of the things that you can actually ask about if you are in fact an employee there. So once you demonstrated the reasons why it needs to change, so if you are Eggers, for example, it's a different scenario. What's the need for restructuring over there? Downturn in the market, this, that, and the other. But whatever that reason is, you can inquire into it. If it's financial, usually it means it's quite urgent. Not always urgent, but then you can truncate those timelines for the consultations. But if it's things like, oh, we had a machine and now they've invented a new machine, and I don't need so many machine minders looking after this machine. Whereas before I had 6 people looking after one machine, I now only need 2. So that's a technological introduction of some new technology in there. So that's okay. But that doesn't mean that now you can truncate that consultation period. Because I can ask you questions such as, is this new machine really going to be living up to the old machine? We knew what we could get. We had lots of work over there, this, that, and the other. So the time period over which the consultations must happen, if it's a financial, if you're losing money, if you don't make these changes this month, then next month you may have to, close your doors. So it can be quite urgent. So that's the concept that I'm trying to bring across, is that the reason for the restructuring very often dictates the pace of the consultations. But once you accept that there is a need to restructure, now remember, there's a problem. The problem is X. I don't have enough customers, or people aren't spending as much as they were before. That's the problem. So first and foremost, I invite you as my employees to a consultation session where we try and solve that problem. Here's my solution. My solution is to restructure and retrench, but that's not the only solution. I accept that there could be others. So a joint consensus-seeking process is the aim and the object of the exercise, where we try and sit down together and consult, and we try and solve this problem. So just because the employer says restructuring is the answer doesn't necessarily mean that that is so. You must look at these things fairly critically and not just accept their say-so. I've got a consultation process underway at the moment where there was a PPE question earlier, people going on strike. Well, somebody tested positive in the factory, and the protocols kicked in, and these people were then excluded. They had to go get tested and get themselves sorted out. But there was a big order, and it was only these two guys who tested positive that could do the work. So management called them out of their sick bank to come and work. And so now all the other employees said, what the hell are these guys doing here? They're going to make us sick. And one of them then went to go and address this issue with management. Lo and behold, he comes to work the Monday thereafter, and he's, there's suddenly a restructuring. Joint consensus seeking process. It's one of those machines that they introduced all of a sudden. So, what's going on there? It sounds a bit suspicious, don't you agree? And if it walks like a duck, quacks like a duck, swims in a circle because it only has one leg, it's probably a duck. So you call them out. We referred that dispute already because they've already dismissed him, saying that his job is redundant. So, yeah, sometimes you just need to run these trials. But the issue is, just because the employer says that the job is redundant and there's a need to restructure, doesn't necessarily make it so. It's a joint consensus-seeking process, and they can't even agree on that. So now, is your agreement as the employee required? It's just a consensus-seeking process. Doesn't mean that we actually have to reach agreement, but I have to give you all the information so that you can see why I'm saying it is so. And that's the issue. In other words, as your employer, I say it's financial. You say, well, is it so? Let me see the financials, this, that, and the other. I say, I'm not going to show you the financials. I'm going to ask you to accept. Here's my auditor. He's independent, and he can answer any questions on the financials that you so wish without me having to give you my confidential earnings as your director. So the audit is there, the information is there. They ask all kinds of questions. We don't agree that it's financial. I say, well, tough is, it is financial. I'm moving on to the next phase. So it's that kind of process. So with that kind of process, it's very, very useful because As an employer, I can move things along. As an employee, I can still ask the difficult questions. And what is the rule of thumb in labor law? The guy who writes the most letters always ends up winning. So why? Because in this dispute, it's going to run for the next 2 years. In 2 years' time, who's going to remember what was said on the 23rd of September 2020? But if there's a recording such as there is now, or you've written it down and you sent a letter, it's going to be a little bit easier for you to relate that dispute, to recreate the issues that you are facing at that time, because you've got a letter. You just have to read the letter. Dear Mr. Employer, I confirm that on the Thursday I queried why these 2 positive COVID-19 positive employees were back. I told you that I felt unsafe. I didn't want to go into the workplace. Eventually you agreed to send these employees home. Then when you sent them home, I came back in and I did a full day's work. And the Monday I come to work and all of a sudden I'm facing this. I think that the 2 issues are related. I think it's unfair. It's that kind of thing. It's easy for you to recreate that dispute in 2 years' time, a year's time, 6 months' time, because you don't have to remember too much. You just have to read your letter. So that's the other thing there, where you can play a big role as a practitioner, is to help guide the queries and to record those things in writing, not on your letterhead, obviously in the name of the employee, because as soon as they see here's a lawyer involved, well, let's just shove all the consultations. We'll bring in our lawyer. So my lawyer and your lawyer ends up having a discussion and we go nowhere because we don't know how to build a boat or whatever it is that the factory manufactures or whatever. We don't know anything about, we just know law. So we send these strategic letters to one another, which is all rubbish. Nobody deals with the main issues that are in dispute. So the starting point is always the need for this restructuring. Then I engage you in a joint consensus-seeking process where we try and solve that issue. Now, one of the slides that I put up there is consultations, substance, not form. What does that refer to? Because the vernier from the employer is that they've got what they call a checklist approach. I've told you about the reason, check. Now we're going to discuss the consequences of it. And the selection criteria and all of those things. And they just go check. But they actually forget to consult with the employees, which is really the issue. That's the problem with these retrenchments, is that they focus on the consultation and they treat it as a bit of a checklist approach, mechanical checklist approach. That's the approach that was discussed in Porter Motors, Karachi versus Porter Motors. It was one of my matters. We lost because my client engaged in a mechanical checklist type approach as opposed to the actual consultations. So in the consequences of the restructuring portion, there are 2 definite processes. One deals with the pure effects of this decision to retrench, and it deals with things, for example, such as how much am I going to pay you? Everybody always remembers that it's 1 week per year of service, but that doesn't mean that you can't agree on something else. So when Reader's Digest, way back when, there was this monthly publication called Reader's Digest, we had lots of subscribers in South Africa, but it was owned by some British publishing, Oxford or whatever. And when they closed down in South Africa, they decided to pay all their employees 1 month per year of service. And their people had been there for 30 years. So they got handsomely paid out. So you can do that. You can do things like, you can agree that severance pay will be, for the first 4 years, it will be 2 years, two weeks per year of service, and thereafter 1 week. So you can do all of those proposals. But again, we were talking about the effect of this dismissals on you. How much money you're going to get? It's an effect of the need to restructure. So before we even get to those effects, we also have to talk about the selection criteria. So if you find yourself in a process where you are the only employee being consulted, and the reason for the restructuring should affect everyone in the department. So let's say it's the litigation department, and the question is, we have too many litigators, we need to reduce the number of litigators. How are you going to make that selection? So surely all the litigators go into a pool, and you then discuss the selection criteria, and the selection criteria does not have to be last in, first out. Last in, first out is the default position. Last in, LIFO, last in, first out is the default position where you can't agree on any criteria, then you use the default position. So your job as a practitioner acting for the employees in a restructuring exercise is to propose selection criteria that favors your client. So let's say you are the matrimonial litigator. So you can say, because matrimonial litigation is on the increase, the selection criteria should be anyone except matrimonial practitioners. That's your selection criteria, that's your proposal. They don't have to agree to it, but that's your proposal. And it makes sense. Why? Because matrimonial is growing, or labor litigation is growing. You can say everyone except matrimonial and labor. Then you can choose, because if you're in a firm that just does lots of MBAs and there's 6 of you doing MBAs, you know, then choose from the MBAs, because that's the section where it's declining. Yeah, so all section 41 disputes goes to the CCMA, because that's about your entitlement to severance pay. Section 189 capital A dispute, a proper section 189 capital A dispute, is going to be where the CCMA facilitates those discussions, because it's a large scale retrenchment. What's a large scale retrenchment? If you are retrenching more than 50 employees and you employ more than 200 people. That's a large scale retrenchment. There's numbers there. So it's roughly 10%, but at a very general level, at least it's 10%. But 189 capital A, it means that the CCMA appoints a facilitator, and that facilitator does your 189 consultations with you. Parties actually come to the CCMA. Leon Levy is usually the facilitator, although there are others. And they run through the consultation topics. They elicit offers from the employer. They try and save jobs. They work it and work the whole process, and they keep the parties there for as long as they need to. For 2 months, they can do that. And they move things along, and they try and limit the impact of those retrenchments. That's section 189 capital A. Doesn't mean it's any different to 189. It's just that it's on a larger scale. Section 41 disputes all go to the CCMA because it's your entitlement to severance pay. Can you go to both the Labour Court and to the CCMA? Yes, you can, but why would you? You'd rather, you know, because you got to do the work twice. So you just combine the disputes and go to whatever the final dispute resolution forum is going to be. I hope that answers that question. Moving on from there, we're still talking about the common mistakes with the retrenchments. What the employer must understand is it is the driver of the bus. All the employees are the passengers. So the employer gets to choose the route or that is going to be taken, the speed at which, all of these things. And as the driver of the bus, you've got to do the running as the employer, we say. So you've got to set the dates for the consultation. If it's a major issue, for example, there's a need to restructure and it's urgent, then I will advise my employer parties, you need to schedule those consultations for 12 hours a day, even on the public holiday, and come in on the weekends to consult because it's super urgent. And if you don't get it done, so that's setting the pace. You as the driver of the bus, you set the pace. You've got to get those deadlines in there. You've got to say, by this day, we need to conclude this discussions, if possible, subject to the consultations. And so you've got to set that pace. If you don't do it and things just waft away, that's your fault as the employer. The employer is the driver of the bus. It must set the pace. The last point on this slide was keep a proper record. And this is, again, it's just got to do with the practicalities of the situation. You try running a trial where you've got no notes about what happened during the consultation session, and it's some 2 years after the events. You try running that trial, I can guarantee you're going to lose as the employer. Why? Because the employer in labor law bears the onus. And this is true for most of these processes, except for the constructive dismissal claim. The employer bears the onus of proving that the dismissal was fair, both procedurally and substantively, especially in labor law. So in labor law, I, as a judge, am no expert about Edgar's and the ability to sell clothes. So when they come along and they say, oh, our ability to sell clothes is severely compromised, we can't do it without restructuring, I, as a judge, I take a back seat. I say, I'm no expert, I can't judge marketing patterns and this, that, and the other. So I'm going to defer to you, Mr. Employer, when you come along and you say, actually, we can't do this without restructuring. But if there has been a question from the employees around why can't you up the marketing spend and do X, Y, and Z, I'm going to see whether or not you have actually dealt with that issue. If you haven't dealt with the issue, then it might very well be unfair. So, but again, the employer bears the onus of proving that that dismissal was procedurally and substantively fair. And for that reason, the big role that you can play when you are acting on behalf of the employer is to ensure that they keep a proper record of the discussions. You know how many times employers get tripped up by very simple questions on the stand, but Mr. Employer, here's a letter from my employee where they raise the picking rates on the farm. Why can't we increase the picking rates? The farmer might have dealt with that issue, but he's got no record of it, so he doesn't know what was said. So now he guesses. He says we can't increase the picking rates because of the bees. And you say, well, that's unusual because that's not the answer you gave during the consultation. Now, if you're going to lie about picking rates and bees on a farm, what else are you going to lie about? So your credibility as an employer, you get shot. And now every single consultation topic is probably going to be determined in favor of the employees with their version. It's a matter of practicality. It's a matter of evidence. Keep a record, keep a proper record, and deal with the main issues, and you'll be fine. So the procedural requirements in a Section 189 process is largely listed there. You have to engage in a joint consensus seeking process where the following topics are typically discussed. It doesn't mean it's the only ones, but it could be some of the more important ones. Is there any alternatives to dismissal is usually the starting point. So alternatives to dismissal, very important, because if you don't discuss alternatives to dismissal and there is an alternative to dismissal, that dismissal is unfair. Why must somebody lose their job just because you want them to? So it's that kind of thing. Alternatives to dismissal. If there are alternatives to dismissal, but they're not practical for you as the employer, then you've got to explain why they can't work. So typically this would be Edgar saying, well, we thought that what we could do was just leave the stores as they are, but if we were going to do that, we were going to run out of money by mid-October. So that is the reason why you rejected an alternative to dismissal, which is to leave the stores unchanged. It is an alternative to dismissal, so you had to reject that. If somebody comes along and says, instead of choosing me to be dismissed, why don't you choose X, Y, and Z? That's an alternative to dismissal, and then you have to deal with the reason why you reject that. So the starting point is always the alternatives to dismissal. My client they were all employed at the National Accelerator Center. True story, all my stories are true. So at the National Accelerator Center, this is, what is the National Accelerator Center? It's got nothing to do with cars. It's got to do with physics. They take the protons and the neutrons and they circle them around this collider, and then they collide, and then they study the properties. In Europe, they've got the Hadron Collider. Well, we've got a mini version out in Fora next to, on the N2, where the ship is. That next to that place is the National Accelerator Center. They study nuclear medicine there. We've got a collider. We've got all kinds of interesting toys. It's a very small collider, and so the studies are fairly limited, but they take different protons, neutrons, electrons, and they smash it into each other and they study the residue. The larger the collider, the more you can speed it up, the electrons and the protons and all those things. But yeah, it exists there. So the lunch break will be at 1. What then happened was they were losing money. They needed to get better colliders in and whatever. So they embarked on a process of selecting people for retrenchment, and they started off with 150. And just by engaging in the alternative to dismissal, we whittled that down from 150 down to 8. So it does work. Alternatives to dismissal, you can discuss those things. We found ways to save money so that they wouldn't need to retrench. There's a question, as you're aware, more often than not, unions, representatives intentionally delay proceedings, especially consultations. Is it advisable to stop them dead in their tracks by refusing these delays, or should little extension rather? So at the end of the day, I've got something on at 1, which is why I need to stop. But at the end of the day, if you don't want to give into the requests for a postponement, it could ultimately affect the substantive fairness of the dismissals that follow. So that's not a good idea. So, you've got to judge these things fairly carefully. There isn't a rule of thumb that you can say all delays won't be anticipated or tolerated at all. You've just got to keep on going. And if it's fair that there be some sort of delay, then that's okay. But what you can do is you set the pace. So because you're the driver of the bus, so as the driver of the bus, you've got to set the pace, you've got to set the consultation topics. And if you see that they are headed for delays, then you just schedule those consultations for longer and longer. Make it 12 o'clock. So tomorrow there's going to be consultations at one of my clients because we set it up that way for 12 hours for the whole day. We're providing lunch. We say we're not stopping this consultations. It's super urgent. Everyone should be available. This is what's needed. It's urgent. It's urgent. It's urgent. And we move on from there. They're going to consult. How long should the delays be? Well, it really just depends on you. But as the driver of the bus, like they always say, you can run, but you can never hide. Eventually, they'll find a space in the diary and they'll crack it. And once that happens, then that's it. That's the issue. So that's alternatives to dismissal. If there are no alternatives to dismissal, then we talk about selection criteria. Who should go and who should stay? It's going to be very suspicious if there's 8 of you in the litigation department and you're the only one that ends up being consulted with and removed. It's just going to be crazy. Why wasn't everyone consulted? Why wasn't all the farm hands who pick the apples on the farm consulted about this? Typically. So how you select people, it doesn't have to be LIFO. That I've made that point before. It could be things like based on who's in charge of that department or in that section, and is it a declining section? So typical example, let's say you are in a practice where there's lots of MVA claims, and the RAF has changed their methodology to say that we're terminating your panel. Some of you might be in firms where that actually happens. If RAF takes all the work, then suddenly there's no need for any of that for those employees. So even if you came there, you got 30 years service, because you are in a section and you can only do RAF claims, and somebody else is in matrimonial or in labor, and their section is growing, you can say, no, why you want to choose me? My section is growing, his section is declining, and he's doing RAF work. He can't do what I do because I went to Mr. Brown's lecture and he was super duper, and now I can do all this stuff. The RAF guy must go, even though he's got 15 years service. That's not unfair notionally. It is something that you can say, and they must consider that, and they must say why they want to keep the RAF guy to now do the labor law stuff, even though he doesn't understand labor law and didn't come to any of these lectures. It's that kind of stuff. So it doesn't have to be LIFO. LIFO is the default position. After LIFO, or after you discuss selection criteria, the next question is going to be what kind of severance pay. So now we're talking about consequences. We are going to implement how much severance pay. What else can you do to help me? So what else can you do to help me stuff is always around the tax. There's a lot of stuff that you can do, up to I think 540,000. So between 30 and 540, it is tax efficient. So you would have been taxed at 41%, but now because you're being retrenched, suddenly your taxation rate, because you apply for a tax directive, those of you who practice in the area of tax law will confirm this, you can apply for a tax directive and SARS will tell you what percentage tax to deduct. Now, it could be as little as 10%, could be as much as 30%, but it's between those sort of numbers, you get some tax relief. Anything between 0 and 30 is tax-free. Anything above that is taxed at a lower rate than is normal. So those are the other additional things. So, for example, I'm retrenching somebody now where they've asked to keep their laptop computer because, well, they want to try and get another job. So the laptop is worth 2,000. We said fine, but not everybody has a laptop, but that's okay. So that's something additional that we could do to help the guy. Your notice period, you could also have a look at those things. So we're consulting in the month of September. October is going to be your notice period. So let's say we finish the consultations today or tomorrow, like we anticipate. The balance of the month of September, we're going to pay you anyway. It's going to cost us a little bit more money, but at the end of the day, it's just going to look better. When the Labour Court has a look at it, oh, what happened to the balance of September? Well, Judge, we said they don't have to pitch up at work. We completed the consultation session and we just gave them that extra week. It's a couple of days. It's not the end of the world. It's not going to cost too much, and it makes you look good when the trial eventually comes along. Judge can see here's an employer who actually thought about things and decided to give a little bit extra. There was a case where somebody was living on the farm and they got to keep the curtains. Can you believe it? How generous. Didn't play a big decision because the consultation and the reason for it was, wholly unfair, but they did get to keep the curtains, I can confirm, but it played no role in the eventual decision on the fairness of the dismissal. But basically the question there is there anything else I can do to help you? If there is stuff that I can do to help you, then I must consider it. A lot of people, for example, they've got bursaries and they've got work back obligations. And then the question is going to be, well, can you please waive the work back obligations? Can I just get the bursary money and complete my studies without having to come back to work? Of course, I'm retrenching you. So I waive that requirement. Next issue is going to be about the restraint. Yes, you can ask for the waiver of the restraint. The restraint is still very much valid and binding, so I can retrench you and at the same time restrain you from competing with me unfairly. And I know that's going to sound unfair, but you know, the reason for the restraint is different from the reason from the restructuring. But there's nothing stopping me from saying, can you please waive the restraint of trade so that I can compete with you in this area? I might have a job with a firm next door. As your employer, I might not like it, but you know, probably going to be fair for me to waive that restraint. But it depends on the circumstances. The question is there anything that you can do to help me? If there is something that you can do to help me, can I ask you for it? And if I ask you for it, what are the considerations? How should we go about whether or not this is going to be something that you should agree to? Should agree,